Good afternoon. Welcome to the First Department. I'll say something that I'm sure you've heard before. We have 16 cases scheduled for oral arguments today. Please ask for the time that you need, not the time that you want. Ideally, we will all want to argue for 15 minutes each, but that's not possible with 16 cases being argued. So please use your discretion on this. People versus Garcia is the first case on the calendar.
The appellant requests 5 and 2.
Is the people here? Yes, I couldn't hear you. Five. 5 and 1 and 5. I ask you, I know the acoustics are not great, so I ask you to please keep your voices up. Vargas versus Winehouse. Appellant Vargas? Winehouse?
I'll request 8 minutes.
Okay, I will give you 5 and 1 and 5.
Thank you, Your Honor.
R. Jose versus Diomara. Submitted. 383 8th LLC. Okay, submitted. Balcazar versus Comet 380. Okay, Appellant Q International 5 and 1. Ergonomics Cross Appellant.
Sorry, Your Honor, I'm ergonomics. The attorney for the,
Well, let me hear from the appellant first.
he's still, Your Honor. I believe he was going to reach out before. Spoke to him earlier.
No one has reached out to us that I'm aware of. Tell me what you want to do.
We haven't been calling you. I'm responding.
Respondent is here from the argument.
And you are cross appellant ergonomics, right?
Correct.
Did he ask you for?
He had told me that he was going to contact the court and ask that they submit.
Okay, and you still want to argue?
I just need 3 minutes.
You're the respondent, right?
Respondent.
And you cross appellant, what do you want to do?
Well, if respondent wishes to argue, then I want to argue. If you'll waive it, I will waive it.
I tell you what, I'll give ergonomics 2 minutes, and I'll give respondent 2 minutes.
Thank you, Your Honor.
People versus Roberts. Appellant request 4 and 1. Please keep your voices up. The people?
Respondent requests 3 minutes, Your Honor.
Thank you. De La Rosa versus Nelson Avenue.
Appellant requests 6 and 1, Your Honor. Respondent requests 6.
Okay. Carter versus New York City Employees Retirement is submitted. Lo Negro versus WFP Tower. So Appellant Tech requests what?
Plaintiff cross appellant 7 and 2, please. Third party defendant respondent 4, please.
Okay, so I'll do 7 and 2 and 7 and 2 for cross appellant and 4. Pacific Alliance versus 1.
Appellant requesting 8 and 2. Respondent requests 8, please.
1 gets 6 and 2. Pacific Alliance gets 6.
Thank you, Your Honor.
People versus Ocasio is submitted. Liberty Square versus Dolphins.
Appellant requests 7 and 3.
Okay, 6-3 and 6. Venezia versus LTS 711.
Plaintiff appellant requests 4 and 2.
Respondent requests 5, Your Honor.
4 and 2 and 5. Umar Kafur versus City of New York is submitted. Mena versus 485 7th Avenue. Your appellant? Okay. Mena?
The respondent requests 5 minutes, Your Honor.
Okay, so I'll do 5 and 2 and 5. South College versus Aris Capital, appellant South College.
Helen sees 4 and 2, Your Honor. 4, I'm sorry, 4 and 1, Your Honor.
South College is 4 and 1. 4. You have a cross appeal. You don't want to rebut? Oh, sorry. So you did. So 4 and 1 and 4. Okay, this is defendant also appeals. Halwani versus Boris Kogan. Submitted. People versus Challenger. And respondent people? Okay. Let's do 5 and 1 and 5. Gian versus American Express is submitted. Isali Lisiaga is submitted. First case for argument is People versus Garcia. Go ahead, Counsel.
Good afternoon. Tom Quinn from Millbank, pro bono co-counsel to the Legal Aid Society on behalf of the appellant, Mr. Garcia. May it please the court. There are 2 independent reasons why the people failed to establish probable cause at the suppression hearing, either one of which would be dispositive. I'd like to start by talking about the description and then talk about the alleged conduct. Here, although we would concede that the description likely led to reasonable suspicion to stop and question Mr. Garcia, it did not provide probable cause to arrest him, particularly when you consider the location, the timing, and the fact that the police had already detained and then had to release another suspect.
But didn't we hear from the undercover that the person with whom he made the hand had first gone to this gone to the defendant, and that they exchanged something, and then he came back and exchanged it with this undercover?
Yeah, so the undercover did not testify at the suppression hearing. What we had at the suppression hearing was the information from the other officers, and the testimony there was that Solano, the co-defendant, approached Mr. Garcia, who's my client. Mr. Garcia handed him a small object, and then Mr. Solano handed an object back to the undercover officer. So that's the testimony that was brought out at the suppression hearing. And this all took place in a deli by the deli counter. And I would like to point out that there's no evidence about what that one object was. There was no testimony about anybody seeing what the object that the deli worker handed to the co-defendant was, nor is there testimony to say that that object was the same object that was later handed to the undercover officer.
But under the circumstances, given the experience of the officers, this is an undercover, that's what he does, that's what they were there for. There was nothing else that, there was no great time lapse between the time that he interacted with the co-defendant and then moved to and then the co-defendant went to the defendant. There was no testimony about any great time lapse. Doesn't that all suggest with sufficiency, especially given the description thereafter?
We do not believe so, particularly when you're considering that this happened inside a deli. The officers, they use their training and experience to identify some kind of hand-to-hand transaction
that
that's a drug deal in an alley, maybe, but not inside a deli where they're supposed to be conducting legitimate business.
Well, the officer had a description, right?
Yes.
And the description was Hispanic, about 5'5". It was inside the deli. Was there anyone that even came close to meeting the description, including a white shirt and red shorts?
Not inside the deli. When the officers came, they didn't see anybody matching that description inside the deli. They went outside and they saw my client out on the busy street.
Right.
It was at 7:30 p.m. on a Friday
Matching
night
the
in summer.
description, right?
He matched certain aspects of the description.
The white
yes.
shirt, the red shorts?
Right, and that he was Hispanic as
Height,
well. Right.
Hispanic.
We disagree on the height. He was shorter than what was described.
Okay.
But we think that that all provided reasonable suspicion to stop him. And
So
that's
your
what the
argument is,
did.
even if the height matched and the clothing matched and all of that, there was not enough for probable cause, there was only enough for reasonable suspicion? That's what your argument is?
Yes, particularly when you know that he's out on the sidewalk on a busy night. It's a half block from the subway, and a lot of time had elapsed between the sale and when my client was detained. Any number of people matching this description could have come by in that time, and in fact, the police did already detain somebody else who matched aspects of this description, and they had to release him. So given that, we think that they needed a confirmatory identification to actually arrest, and there's no reason they couldn't have done that here. They described my client as, quote, very cooperative, and he was not fleeing, there was no sense of danger. They could have just waited to have the undercover officer come and do a confirmatory ID.
But didn't the undercover officer actually do a confirmatory ID?
Sorry, Your Honor?
Didn't the undercover officer actually do a confirmatory ID?
Not until after the arrest. They arrested without a confirmatory ID. That happened based on another officer who had the same description, came up and saw my client and said, yeah, I agree, he matches some of the aspects of the description, and that's when they arrested. And that's the critical mistake here. They could have just waited and had the undercover officer come and do a confirmatory ID, since the undercover is the only one who had ever laid eyes on the suspect.
And it's conceded that he was cooperative and had agreed to wait.
Yes, Your Honor. And so they should have done the confirmatory ID first, and
thank
reserve
you.
for rebuttal.
Good afternoon, Your Honors. Rebecca Hausner on behalf of the people. Many of defendants' arguments essentially add up to an attempt to either ignore or drastically narrow the fellow officer rule. In this situation, we have a positive bias.
Do you want to start with where he ended? I mean, he's basically saying, rather than arrest the defendant because he fit the description, at least generally, wouldn't it be appropriate, particularly with a cooperative defendant or person being detained? He wasn't a defendant then, right? A person being detained who clearly agreed to wait.
Mm-hmm.
So it could have been 10 minutes before the undercover would come and identify him.
This could have been a situation where the undercover officer came first to identify defendant, but that's not required. And there's nothing in this court's law that requires a confirmatory identification.
It's not required, but this is all based on the facts. And he's saying that the facts here are red pants or shorts, that was not clear, and white shirt. Okay. He said that was general, but be that as it may, there was some time in between the undercover identifying and the arrest, and it's a store, and the person wasn't inside, he was outside. So there were other factors that made this not, he's saying, made it not quite as clear as, you know, the people that as you're alleging.
Yes.
So under those circumstances, given the other things that came in between, and that he was standing there being cooperative, why wasn't it just as well to do the confirmatory? Because without it, is that probable cause?
It's the people's position there was absolutely probable cause, and notwithstanding the fact that this may have been an imperfect situation, an imperfect scenario, there still was probable cause to arrest in this situation. And that's for several reasons. Of course, you have the positive buy signal from the undercover officer. You have a communication explaining that there were 2 defendants involved. And then, of course, you have descriptions of both of those people. And this court has held in the past, I'd point the court to People v. Robinson, cited in the People's Brief, has held under similar circumstances that is enough. Now, turning to the purported inconsistencies in the description, I would like to emphasize that many of those inconsistencies were not drawn out fully below at the hearing court level, so therefore, there was nothing at the hearing court to actually establish defendant's height or what he was wearing, whether or not it was red shorts or red pants. But at the end of the day, those purported inconsistencies were not enough to undermine probable cause. You have a defendant who is wearing red bottoms, which are fairly distinctive, white shirt. He's notably shorter than the typical average man in the United States, whether or not it was 5'5" or something less than that. There was enough from the undercover to convey that we were dealing with someone short in stature, and of course his race and his gender. And looking at all those factors together, there was enough for probable cause. I would like to just turn to the argument that defense counsel makes that there was some sort of protracted timeline in between the undercover's transmission and when the arrested defendant actually occurred. Yet again, that is not something that was fully explored below at the hearing court. There's an assumption made both by defense counsel below and now again on appeal that this was an extremely protracted timeline, where the fact of the matter is the time actually wasn't established before the hearing court. And given the facts that the arresting officer testified to in terms of what he did before stopping the defendant, there's no reason to assume that it was anything more than a few minutes. And in fact, the people would argue that the fair inference is that nothing more than a few minutes actually elapsed. But again, the timing was not fully explored below. The facts that we do have, though, from the hearing record do establish probable cause. Thank you.
Thank you, counsel.
To pick up on the timeline issue, although the exact time in minutes was not before the suppression court, just think about the timing and the things that happened from the sale to when Mr. Garcia was stopped.
Yeah.
First, they have to make the positive buy sign. They follow the co-defendant around the block, down the corner. They detain him. They bring him to their prisoner van. And then they detain a second suspect that they think matches this description. The undercover officer looks at that person and says, that's not the right guy. Then they have to go back to the deli. They go inside, don't see anybody matching the description, and then go out. And that's the point that they find him. And all this time, you've got people coming and going down the street with a subway stop right on the corner. And also on the timeline, although it was not before the suppression court, I would submit to your honors in the record that the People's Voluntary Disclosure Form says that it was 25 minutes. So this was not a bang-bang operation, and that was all evidence that was before the suppression court. We, again, submit the conduct was innocuous too, and for all of those reasons, we think that you should grant the suppression motion, vacate the conviction, and remand for a new trial to be preceded by an independent source hearing. Thank you.
Thank you. Great job, both of you. Counsel, please thank Milbank for the services that you provided to the defendant and to the Legal Aid Society.
Yes, Your Honor.
Vargas versus White House. Go ahead, counsel.
Good afternoon, Your Honor. I am Stephen Woodham with the Yankwitz Law Firm. I represent the appellant, Christian Vargas, in this matter. May it please the court. This is a personal injury action that occurred on March 4th.
Yeah, I mean, we're familiar with the facts and the procedural history of the case.
Okay.
Did your client get workman comp?
He did, Your Honor. So that's part of the factual.
From his employer, right?
Yes, so his employer was United Pickle Factory.
Right.
The boss or the owner was Marvin Winehouse.
Right.
But his mother happened to also be the owner of the property, and there is a power of attorney in the record that indicates for the past 20 years, he was taking care of the affairs of his mother. That
Right,
included-
but she had not, I mean, you sue Corinne Whitehouse as owner, right?
Pardon me?
As the owner, right? And she, as the owner, has a lease with her, is that?
With her, it was, she co-signed a lease with her husband who passed away, and the lease was with her son, Marvin Wisehouse, in charge of United Pickle
Right,
Factory.
so why isn't she an out-of-possession landlord? The lease is what governs the responsibilities with respect to the workplace, right?
Well, it is our position that she's an in-possession landlord based on the power of attorney. She was using her son as a managing agent, a de facto agent, for the past 20 years. And regardless of whether...
Isn't the lessee a different corporation? The son
Yes.
is another corporation.
Yes, but that's the question of fact, because we didn't have a chance to do depositions in the matter. Well, let me take that back. We did depositions. Plaintiff's deposition was partially held. Due to his pain, we had to adjourn it. So and the parties agreed to bring him back for a deposition and have all the defense deposition. But defendant moved prematurely for summary judgment. We never had the chance to depose Corinne Wisehouse, Marvin Wisehouse, or even continue plaintiff's deposition. So that's where the issue lies. And additionally, regardless of what...
Is there any case that you have or any law that says that by giving her son the power of attorney, that takes her out of the legal definition of an out-of-possession landlord? Because I think she testified that she hadn't been there in a really long time and only wants to pick up her family to go to a party.
May I just correct? She never testified. It was her son, I believe, in the affidavit.
Okay.
So regarding whether there's out of possession or in possession, it's also plaintiff's position that that term of art doesn't matter based on the Zhang Fu fee decision, the Court of Appeals, which kind of changed the landscape. So now with New York City Administrative Code, New York City 7-210, whether you're in out of possession or in possession, which I brief in detail, it doesn't matter anymore. So you could still have...
So that takes us into where the accident actually take place, right?
Pardon me, Your Honor?
That takes us into the question of where the actual accident.
Right, and
took
plaintiff's
place,
position is, also because it was a premature summary judgment motion, we had to rely on an affidavit. We circled, the plaintiff identified where in the picture his accident was, circled it. Granted,
Right.
it was a after-the-fact picture, but that succinctly identifies that it was on a public sidewalk that was also used as the driveway into the factory.
But wasn't that circle, I looked at that photograph, didn't that indicate an area that was within the loading dock walls of the building?
So the loading dock was actually inside, so that was also a public sidewalk. So when you're looking at that circle, that's a street too. That's a street with a driveway.
Well, isn't it the entrance to the United Pickle Warehouse?
Well, that's also part of the question of fact that we didn't have a chance to explore during depositions. It is plaintiff's position that inside, that's where the accident happened, outside. You'll also note there's two pictures that were part of the affidavit. There's one where it's an employee's pointing inside. That's not where the accident happened. It's where plaintiff circled, yes.
Right.
And that was also the public sidewalk in addition to a special use driveway.
But that's the area that's circled after the repairs are done.
Correct.
And
And if you look at Marvin Weishause's affidavit, he admits that the pickling operation, the brine, messed up the sidewalk. There was defects and depressions
Yeah,
inside.
I understand, but the area that is with the repair, it seems to be on the inside.
It was repaired both inside and outside because that's the pickling operation. They would take a forklift.
Where the circle was, I'm talking about. Where
The circle is outside. That was repaired. That circle is on the outside.
Which was a pertinence to the premise, right?
Well, our position, it's not an appurtenance. It is the public.
Because you relied on that
Uh,
23E's case.
Defendant relied on Stockman.
Mhm.
And if you look at the picture cited in that decision, where the plaintiff fell in that case, she's actually under an awning coming out of a bar. So that's not really on a public sidewalk.
Right.
And again, all plaintiff is arguing that there's a question of fact. We never had the opportunity to flesh out these details despite the preliminary conference order, compliance conference order, and the multiple attempts to schedule a deposition. So my client was kind of hamstrung of what type of evidence he could provide.
Okay. Thank you, counsel.
You're very welcome.
May I please?
Just give me 1 second, counsel.
Absolutely, Your Honor. May it please the court, my name is Daniel Kotler from Lester Schwab Katz and Dwyer on behalf of defendant respondent Corian Whitehouse. Your Honors,
So why isn't it an issue of fact where the accident actually take place?
so if you look
We
at,
have contradictory information about where he was and who's responsible for that area, no?
well, I think that's two different questions, so if I may, I'll take
Yeah,
them one
you
at
know,
a
we
time.
always ask compounded questions. Go ahead.
If we look at page 151, where plaintiff taking the circle that plaintiff put on it, as I think Your Honors understood, looking at this picture, we have the plastic, whatever you call that, on the curtain, and we have the door frame, and this is right at the door frame. This isn't out on the sidewalk. This is right at the door frame. That's plaintiff's own testimony. Well, circling. In terms of who controls the area.
Where is the conflicting evidence as to that area where he fell? And to me, the picture looked like he was in the loading dock area. Plaintiff says, but there's conflicting testimony that was really outside. Is there anybody's testimony that you can point me to that shows where there's conflicting testimony as to that issue?
I can't, Your Honor. I would, my position is that there is no conflicting testimony.
I'll ask plaintiff.
I think plaintiff tries very hard and diligently, working zealously for his client, advocating, to pretend that there is, but there just isn't.
Well, this is a vehicle that has one wheel, and the wheel is in the back of the vehicle. Isn't that right? He's on one of these things that moves pallets and such, right? And the wheel is on the back.
I
as he
don't,
describes it?
respectfully, I don't remember how many wheels the vehicle has.
Okay, well,
It's a forklift.
it's a forklift, yeah. Okay, well, I guess plaintiff's attorney will clarify.
Okay. But if it's, regardless,
counsel,
the
counsel,
alleged defect is,
picking up on Justice Renwick's question, if the vehicle is, as she says, when the accident occurred, was part of the vehicle already inside the premises? Or was the entire vehicle outside the premises?
Yeah, I mean, 'cause that's the question, right? You got plaintiff is really saying what?
plaintiff
That
is,
you're negligent because in allowing the entrance and the sidewalk to be cracked and broken. We have a circle around where the accident allegedly take place, but that's not clear as a matter of law, is it?
plaintiff testified, he said the first floor, though plaintiff's counsel very strongly opposed allowing him to say that and objected very strongly, but the questioning is clear. Looking at this photo, regardless of, even if there were part of the forklift that had already reached outside or that was further on in the driveway, this area that plaintiff circled is in the doorway, the area where the defect is, and therefore the area where there would be responsibility to maintain is there. If the forklift had fallen over.
But the owner of the building admitted that there was brine, et cetera, that damaged both the sidewalk and the area that was within the garage. So the broken parts were in both places, right?
I'm sorry, can you repeat the question? I didn't.
I said the owner already, not the owner, I'm sorry, not the owner, her son, the owner of the pickle factory, already indicated that the brine, et cetera, caused damage, erosion to the outer part as well as the inside part.
He attests that there is damage from the brine.
To the outside part, that's the relevant point of my question, the outer part as well as the interior.
But I would say, I would submit that the relevant issue is where this defect.
Well, that's
occurred,
exactly the
where
question.
plaintiff
Outer
fell.
part
And
as
plaintiff-
well as the interior part.
It's a plaintiff circled,
No,
again, this
you're not
clearly
answering
is
my
the loading
question.
dock entrance.
If you could answer my question, okay. All I'm asking you to confirm that the owner of the pickle factory indicated that the brine caused damage to the outer part as well as the interior. Isn't that true?
I'm thinking back to the deposition. He testified that the brine affected the loading dock floor. I don't have the affidavit in front of me, if you will allow me to flip to it.
It's okay, I don't want to take up time, and I know it's in there, so.
But I would submit, even if there were a defect caused by the brine elsewhere, plaintiff's testimony was clearly, and plaintiff's own photo shows that where the accident actually happened.
I think it's at the record at 134 to 136, where Mr. Leibowitz acknowledged that the salt and brine caused damage to the premises and adjacent sidewalk.
What page did you say? Because I'm looking at page
I think it's
105 for the depositions of the.
the record,
Record.
134 through 136, and then
134.
again on 147.
This is not enough. This is.
Okay.
Yeah.
all right,
The
it's,
affidavit is on
what?
105.
Okay.
Okay, counsel.
The brine and salt caused damage to the concrete floor. Yeah, he does say also the sidewalk. But again, I would submit that the defect area, even if there was a defect somewhere else, that's not relevant to this accident, and that brings to causation. May I, although I recognize my time is up, may I address the prematurity briefly?
I'd rather you did. Thank you. Counsel, you got 1 minute.
I know Your Honor had a.
I just want to ask you one question. The plaintiff says that this is a forklift and the only wheel is on the back.
I was going to.
I'm
that
just
was-
trying to clarify whether or
was-
not he's saying that the accident happened at a point when, I guess that, he says the wheel hit.
That was going to be my first
Okay, go
point
ahead.
I wanted to address.
Go
So
ahead.
it's two wheels in the front and one wheel in the back. So it's the back wheel and the back wheel is what gets stuck. And additionally, it is premature. This is the whole question is where the accident happened. It's plaintiff's position. It happened outside. And I think a very telling piece of testimony, if you look at the record on page 86, defense counsel asks, around the date of the accident, March 3rd, 2014, generally, trucks park somewhere on the sidewalk of the exterior of the building. Defense counsel recognizes that's a sidewalk, or would they park on the street or something else? So, my client says on the street, indicating that there's the street, there's the sidewalk, and then there's the factory.
Okay, thank you.
Thank you for your time, everybody. I appreciate it.
Thank you both. Balcazar? Okay, I give you a couple of minutes each.
Good afternoon, Your Honors. May it please the court. My name is Richard Bogle. I represent the ergonomic group in this case. You know the facts. The court below found there to be a question of fact as to whether my client Ergo.
You're saying ergonomics wasn't on the property, didn't manage it, and didn't direct the workers.
Correct. They had no control over the means and
But hired
methods.
Quick and the
Atlas Acon, the
Atlas
employer.
to do the work?
Yes.
And you were otherwise free from negligence, right?
Yes.
And you had no workers on this site. You hired other people to do the work. You were just.
Correct.
Right.
We had one person who come in once, twice a week to check on the progress of the job.
Was
Okay,
this
so you
person,
should, should have been granted summary judgment dismissing the third-party action, right?
Correct.
That's 4 for 4. I would sit down if I were you.
That's what I'm going to do.
So let me hear the 2 minutes from the other side.
Good afternoon, Your Honors. David Feehan, representing the building owners, third-party plaintiffs. This is a demolition project, Your Honors, and Ergo signed up to perform demolition inside of this building on 3 floors. They failed to acknowledge that they were a demolition contractor. They subbed it out to someone else, and they subbed it out to Quick. Quick did the move out of the equipment. Quick subcontracted with Atlas Acon plaintiff's employer. Quick would talk with Mike Kelly of Ergonomic Group for coordination of where are we going next, what room is being disconnected, because Quick would follow the electricians. The electricians would disconnect the computer equipment, Quick would follow, move the computer equipment.
was Ergo telling them what to do and where to do it and how to do it?
Judge, all I have to do is create a question of fact. Ergonomic was had they been a main defendant, Your Honor, they were an agent of the owner, and Quick was a
So
contractor.
your argument is, the issue of fact is whether they could have coordinated the work of Quick and Atlas Acon, right?
Yes, Judge, it was the coordination of trades. They put the 2 trades in the same room at the same time. And as you can see in the photographs on page 608 and 610, there are, the cabinets, there's about 100 cabinets being removed. Every single cabinet had a hole underneath it. At the time of the accident, there were 100 holes on the floor. So they should have put something over it. They should have had someone else put something over it. It was a demolition project as determined by Judge Edmead, and they contracted to do the demolition work. The contract says that they're going to do the work, and then they subcontracted it out.
Okay.
Thank you.
Thank you. Thank you both. People versus Roberts.
I'm
Justice Renwick has recused from this case. Go ahead, counsel.
Okay. I'm sorry. May it please the court, Lauren Springer for appellant Roger Roberts. A 16-year prison term and 5-year post-release supervision period is unduly harsh for Mr. Roberts, who is an
I mean, the maximum here is 25.
Yes, Your Honor.
And the minimum is 5 years.
Yes.
And he got 16.
Yes.
So somewhere in between.
He had somewhere in between.
I understand that he has no record. He had no prior record. I also read your briefs regarding his distinguished service as a Marine in the armed forces. But didn't the court take that into account? Particularly on the resentencing.
On the resentencing, yeah, they had that information, but this court still has the power to modify.
Indeed.
And it's our position that 16 years is still unduly harsh, given everything that you've cited, including the fact, too, I mean, of the matter is that there is precedent for giving leniency to people who are vets, and he struggled in his post-civilian life. When he, you know, you take note of his good record, military service, but he did struggle when he came out. He had.
It did, but don't we also, in exercising our interest of justice jurisdiction, don't we have to be concerned also with the nature of the crime? I mean, he strangled his girlfriend to death, and I don't want to go into all the horrible details, but that's a pretty serious crime.
Granted, it's very serious, and nobody is disputing that what happened to Ms. Roland wasn't horrible. But I think that there is a balance here. I mean, I think what I'm arguing for, asking the court to do, is reduce the sentence to no more than 10 years, and I think that does balance out the seriousness of the crime, also with the mitigating information that we've presented to the court.
Has he dealt with his alcohol addiction?
He
Were
has,
incarcerated?
he's been sober since he's been, after his arrest, and he's maintained that, is my understanding.
Is that because he has control of it or because he cannot acquire it in?
You can, I mean, this is the thing, people can get tickets for substance abuse issues, so it's not as though it's not, it's that you can't, you don't have access to it. It may be more difficult, but you do have access to it still. And he's managed to maintain that sobriety. He was focused on being disciplinary free, on his programming, and basically just trying to deal with his medical issues and to adjust to life in prison. I mean, this is his first ever prison sentence. I mean, he has got no, except for one arrest back in 1986, this is his only conviction, his only contact with the criminal justice system.
Okay, thank you, counsel.
Good afternoon, Your Honors, Counsel, and may it please the Court. My name is Reva Grace Phillips, and I'm here today on behalf of the respondent, the Bronx County District Attorney's Office. Defendant validly waived his right to appeal orally and in writing. As such, this Court should find that he is foreclosed from challenging his sentence as excessive. Even if this Court does find that the defendant did not validly waive his right to appeal, his sentence is eminently fair and reasonable. And while I would like to briefly touch on the waiver of the right to appeal, I want first to go straight to what Your Honor was just discussing with counsel, which is that defendant had an alcohol issue that he alleges led to this severe crime in which he strangled his intimate partner to death in an act of fatal domestic violence. I would point specifically to the fact that this is a defendant who also acknowledges he prior had periods of sobriety. Defendant, in fact, says in his pre-sentencing memorandum, his sentencing memorandum for the resentencing, that he was sober for a period of 6 years. So even if defendant is sober now, while he is, as Your Honor pointed out, unable to obtain alcohol, that is no promise of future sobriety. And that
But isn't that always the case when it comes to drug or alcohol? I mean,
Yeah.
you always, but one step away from it. Once an alcoholic, always an alcoholic. Isn't that what we always hear?
Absolutely, Your Honor, and that's why his sentence of 5 years post-release supervision is eminently reasonable.
But that has never, I mean, the fact that you're always one step away has never prevented this court from exercising its interest of justice jurisdiction in
That's correct.
instances where it's warranted.
Yes, Your Honor, that's correct. I would argue first that this is not a sentence where it's warranted to reduce it all because of the severe details that Your Honor referenced earlier. And the second thing that I would point out is this is not a defendant who's raising the general concept of relapse as a part of recovery, but this is a defendant who's now arguing specifically he's recovered in prison and that should help this court feel comfortable reducing his sentence. I would push back on that concept by pointing out that this is a defendant who has had prior periods of sobriety. Your Honors, this defendant did validly...
Why would that be different if he does all 16 years as opposed to, say, 10 or 12 years?
Your Honor, I would begin by saying that the sentence is fair and valid based on the crime. I would then go straight to Your Honor's question, which I think is relevant in terms of is he capable of recovering with less time in prison? Perhaps, but the point is that he has this sentence that validly reflects the severity of his crime, that he also has a period of post-release supervision that, as Your Honor rightly pointed out, was considered as recently as 2019 with the same factors raised by defendant. And even at that time, the court specifically found that given his alcohol addiction, post-release supervision made even more sense than it might otherwise. If Your Honors have no other questions, I will rest on my brief.
Yeah, no, I think we're good. Thank you so much.
Your Honors.
Okay, you got 1 minute, counsel.
I'm just going to be brief. I'm just going to say that the oral and written waivers of appeal are invalid and that this court can reach the sentencing issue. Thank you.
I'm familiar with your argument, the confusion that you claim your client experienced, and he wasn't even sure that he had retained his appellate rights. So
Yes. Thank you, Your Honor.
thank you. Thank you both. De la Rosa. Yes, oh no. counsel.
May it please the court, Mike Chuvin for Appellant Nelson Avenue Properties. As your honors are aware, this was a jury verdict that was only allowed to hear evidence of compensatory damages about a victim who was struck in the back of her neck from sheetrock from above. Yet from start openings to finishing, even jury charges, there was evidence of punitive damages that permeated the entire trial. And your honors, there were prior bad acts alleged, illegal conduct alleged, failure to have guards on a window. That had nothing to do with what the jury was ultimately led to decide. Again, they had one decision: compensatory damages, how to compensate this victim for being struck in the head and neck. My trial counsel asked for a curative instruction. Get rid of everything that they heard, everything from the start, everything about prior bad acts. 3,000 HPD violations were alleged. Then it was 320 HPD violations were alleged. The trial court made a great finding. She said, none of that was ever proven. Yet the jury heard it.
Well, they were not proven to the extent of warranting punitive damages, not that the jury could not consider it in order to determine compensatory damages, correct?
So no, Your Honor, I just disagree. On page 665 of the record, Judge, and I think she made a great decision. She said, you referenced, counsel, 320 violations, but you never once showed it to the jury. You never once got it into evidence. So from our perspective, no, it never got in. And why would 320 HPD violations, which we don't even know what they're about, they could be related to a guard. They could be a slip and fall on the floor. They had nothing to do with, again, liability was conceded. So they had nothing to do with what the jury decided, because punitive damages were now taken off the table. So it was incumbent on the judge to say, hey, you may have heard evidence, but this is what we need to do.
Counsel, did
Yes.
your trial attorney, and maybe you can reference me to the page, specifically request that the judge make a specific charge about the issue of what happened with the punitive damage? She was, I mean, we understand she allowed that in and then ultimately did not allow it to go to the jury. But did the defendants, did your trial counsel specifically request any type of curative instruction? You said he or she did. I wasn't sure where that was.
Sure, Your Honor. If you turn to page 664 of the record, so they were having the charge conference, and during the charge conference, that is when oral argument on punitive damages was held.
But after that was denied, did the defendant object to that when I'm over here.
Oh, I'm sorry,
It's okay.
masks, I can't hear you.
Notice everybody
No.
looking this way.
You were nodding, Your Honor, so I thought.
Can't tell where the voice is coming from, I understand. But, you know, there were some objections, and some of those objections were sustained, and then they had the charge conference, you know, with regard to a curative instruction. But did the defendant, after the judge said, well, I'm doing this, did they make an objection? Did they object to that charge?
Yes, Your Honor.
They did?
So here's what happened, Your Honor. On page 664 of the record, during the punitive damage section, he said, if Your Honor grants me my motion, I ask that a curative instruction be given, that all testimony of Mr. Joseph be stricken completely. Then, the next day, the judge decides the punitive damages. And he said, and counsel points this out, he said, I want the jury to know that we want our motion on punitive damages. And the judge said, well, that wasn't before the jury. They never heard the term punitive damages. The next line on that, he says, but Your Honor, the issue of Mr. Joseph. And when you look at that compared to the prior page on 664 where he said, I want all testimony relating to Mr. Joseph completely stricken from the record, Your Honor, we do believe that it was preserved then. And it goes a step further, because he wanted Mr. Joseph's testimony stricken. During the jury charge, the jury was told they were given an interested witness charge about Mr. Joseph.
But you did not object to the jury charge, did you?
We objected during the charge conference on the punitive damages, Your Honor. But when the interested jury charge was given,
Right.
we did not object at that point.
Right, and usually once the judge, because you may agree on what's going to be charged, but sometimes the judge will skip something or not.
Right.
In this case, you need to object after the delivery of the jury charge, right?
Well, Judge, we could
And
do.
there was none. You didn't take exception to any of it.
Judge, we did, because it was during the conference that we said it shouldn't be there. So when she gave the charge, it's preserved at that point. We don't have to do it after, because she said she was going to do it.
I see.
So we already made our objection. And real quick, I just want to turn to another issue we raised, which was the Fry hearing. We had a biomechanical expert that, Your Honor.
Go ahead, I'll give you 30 seconds.
Thank you, Your Honor. Our biomechanical expert said, I was trained to do these testing in the Air Force. I've done it for 15 years in the Air Force. And the judge, in saying he could not testify, said there was no support for where he learned how to do the testing. There was no scientific evidence to support how to do the testing. And Your Honor, given
Right, I mean, the court basically said there were no control studies, clinical data, supportive proofs of peer review, medical review. None of that was present.
Right, Your Honor, in the references. But his direct testimony, which can be used, and he gave a synopsis of what he was relying on in his reference sheet, he did say, I was taught how to do this in the Air Force. I did in the Air Force. He referenced NASCAR and NASA, who also do the exact same testing. I appreciate
So, but the court, see, the court was clear that, I mean, his credentials are impeccable.
Yes, sir.
Right? That's what the court said. But then, the court also said that he failed to show the methodology that is generally accepted, right? That's what was missing.
Understood, Your Honor. If I could just answer that real quick.
30 seconds. It's
Thank you,
not
Your
a
Honor.
problem. The clock is usually for you folks, not for us. So.
Okay, Your Honor, the way he said it was that I was trained to do it. So he was saying, I received this training in the Air Force. So the Air Force is where he learned it. That should be, in our position, enough to say he should be permitted to testify about dropping. He did a drop test. He dropped it on a person, he dropped it on a test dummy to measure the force that impacted it and the impact it had on the spine.
Okay,
Saying that he learned it there, we think is sufficient. And I appreciate Your Honors for the extra time.
thank you.
Good afternoon, Your Honors. My name is Chris Savaro. I'm an associate Pollock, Isaac, and DeSico on behalf of the plaintiff respondent, Ms. Nalcida de la Rosa.
Do you want to start where he ended? I mean, why isn't it sufficient for him to lay out his credentials
Well,
and where he learned it?
sure. Well, he can lay out his credentials. There's no real showing that his credentials actually supported this test that he was doing. I'm not familiar, and he didn't explain why the Air Force, NASCAR, and NASA are dropping things on people's heads. But I guess we're supposed to just take it on his word that that's where he learned it. But as Justice Kearns noted in the decision we quoted, and she was quoting Justice Sachs as well, we need more than the experts ipse dixit, or to just pull it from the ether and say, take my word for it, I promise you this is sound methodology. And now, while my learned colleague argued that he did a drop test, I would like to note that there's a very clear disparity between his 3101D, which says that he actually conducted testing on his male employee. That's at 1109 through 1110. Whereas at the Fry hearing, he testified specifically that, quote, he performed no specific testing for this, but he did have access to testing, unquote. And that's at page 562 of the record. So what we're left with is a very credentialed expert who basically did nothing in this case. He just had a lot of articles about, car accidents. He had articles about the NFL testing better helmets. And he even submitted a peer-reviewed article of his own, which the trial court took special effort to indict him on, that dealt with low-speed automobile collisions. Now, opposing counsel argued extensively in...
Was there anything in the 3101D or any other testimony that this expert gave showing that he had experience with this particular type of accident? I mean, I know there was some about car accidents, which, has nothing to do with this, but the falling accidents, I mean...
Well, in the 3101D, as well as during, he referenced the saturated building materials that were dropped on an employee at some unknown time. But he admits that he didn't perform that testing specifically for this. He also admits that he had no idea whether or not there was other debris. He basically disregarded the plaintiff and her daughter's testimony that wood and rock and all sorts of things fell on her. He had no idea what position she was in. So none of the testing that was performed, which also included reference to 2 experiments done by his organization regarding small ceiling tiles being dropped on an amorphic dummy that doesn't actually measure up to the plaintiff's measurements at all in terms of.
So what you basically, you're explaining what the court below did. Impeccable credentials, but unclear how they apply to the facts of this case and how that expertise was used in terms of methodology.
Correct, Your Honor. There's no support for his methodology.
Counsel, I'm also concerned about the first issue that counsel raised about the punitive damages, even though that might not have been used. So the jury was allowed to hear a lot of testimony that would have gone to a determination of punitive damages had the court allowed punitive damages to go, but obviously we know the court did not. But did the court give the correct curative charge, and was she asked to do that? Because would have been a lot of testimony, it seems, that really they should not have considered in determining compensatory damages.
Yes, Your Honor. I think there's a few things to be said in response to that. And the first thing I'll note is the only very clear request for any sort of curative measures was that they not be charged with punitive damages. That was granted. If anything, the error below was not to present this issue to the jury. Now, we go through the law in extensive detail in our brief that there's no requirement as a matter of law that punitive damages not be brought before a jury at the same time as compensatory. The whole line of...
You mean testimony or evidence for supporting punitive damage?
Correct, Your Honor. It's just the amount that has to be separated if that evidence is sufficient.
I'm sorry.
But was that explained to the jury? I mean, I'm not saying that you didn't, that they didn't have the right or you didn't have the right to bring that to the jury, but once the judge decided not to charge punitive damages, did she have to do more? Or did she do what she did correct under the circumstances?
Yeah, I believe that is correct, because she also instructed them not to, the instructions are clear, that she said you do not have to trust any of the witnesses. They gave an interested witness charge to the plaintiff. They also said that you're not supposed to be motivated by your feelings, which is essentially what the punitive damages go to. And absent a clear objection from the defendant regarding this missing charge, I don't see how it's relevant. And it's worth really highlighting that they've abandoned any claim that the verdict was excessive. They never polled the jury. Yeah. They're just saying we have an appellate attorney who's come in, he's done an excellent job of trying to save his client from a prior attorney's disastrous decisions prior to and throughout trial. I don't think that the sole issue of punitive damages, you can just speculate that that's what influenced this very reasonably, undisputably reasonable verdict that was awarded to the plaintiff.
Yeah, but you agree, though, that to allow testimony referencing 1,000 violations that are unclear whether they even relate to this case, and then failing to introduce any evidence whatsoever to support them, can prejudice the appellant in this case.
Potentially, but you would have to prove that. But also the other things I would note is two things. I went through and I compared the amount of pages for expert medical witness testimony as opposed to just fact witnesses. There is 127 pages of fact witness testimony, some of which included medical treatment. And then the medical doctor's testimony is 242 pages. So if you look at the Calzado case, and that talks about a mere isolated reference to inappropriate comments, that's clearly overwhelmed by the very strong case that the plaintiff had with respect to her crippling injuries. And I'd be happy to continue talking.
No, I'm fine. Thank you. Okay, you get 1 minute, counsel.
Thank you, Your Honor. And thank you for counsel for what he said about me as well before I start. Your Honors, specifically on page 664, I reference this to Your Honors. Counsel said, perhaps we can do some sort of cumulative charge before we go. Everything should be stricken from the record regarding what Mr. Joseph said, because it's irrelevant if you rule in my favor on punitive damages.
And what did the judge say?
I'm sorry, Your Honor?
What did the judge
The judge said, you'll have my decision tomorrow. She issues her decision the next day, and then...
And what did she say exactly in her decision the next day? I'm going to do something?
She said, I'm denying, this is a negligence case. Punitive damages are not warranted.
But she didn't specifically say, and I'm going to give a curative instruction as requested.
Correct, she never did. And so that is our big issue, Your Honor. And one thing I do want to point out, and I rarely cite to this court United States Supreme Court cases, but State Farm Automobile versus Campbell, 538 U.S. 418. The court said vague instructions or those that merely inform the jury to avoid passion or prejudice is not enough when punitive damages are there. When prior bad acts are there, we got to take a step forward. And that's what we don't think occurred here, that there was not that extra step to protect against what was said to the jury. I appreciate Your Honor's time, and unless any other questions, thank you.
Thank you. Thank you both. Lo Negro. Okay. Go ahead, counsel.
May it please the court, Matthew Rosen on behalf of the defendant appellant respondents in this matter. Your Honor, first thing I'd like to address is the issue of the Aaron's authorization in this matter, which it has to be emphasized that Dr. Kim in this matter provided an affidavit to the defendants after having received an Aaron's authorization that had all the proper instructions that are set forth in Aaron's. He provided this affidavit stating before the note of issue that the plaintiff's injuries all had a nexus in a pre-existing condition.
Was this affidavit something that Dr. Kim all of a sudden decided to do on his own, or was it something that the defense attorney requested and possibly even put together for Dr. Kim to sign?
Your Honor, the affidavit was subsequent to a conversation, as was requested, with Dr. Kim. Dr. Kim expressed his opinion to counsel, and yes, the defense counsel put together.
It was you say a conversation. They characterized it as an informal interview, right?
It's an informal conversation. This is a telephone conversation between counsel and Dr. Kim.
How far is counsel supposed to go when he receives an Aaron's authorization?
I'm having trouble hearing.
How far is counsel supposed to go in the conversation when he receives an Aaron's authorization to speak to the treating doctor?
Well, I'm still having trouble. The Aaron's authorization was forwarded to Dr. Kim. Dr. Kim agreed to speak to us. And after having the conversation with Dr. Kim, the counsel determined that, or asked Dr. Kim if he'd be willing to sign an affidavit to the effect of what his opinion was.
But the thing is, didn't this really go beyond what the limited parameters of Aaron's usually permits, which is an informal interview of an adverse party's treating physician? To have him sign an affidavit to the extent that your clients had, and I think he did later say, because we know he put in another affidavit that at least creates an issue of fact in which he said that you prepared it for him and had him sign it.
Your Honor, I would emphasize that Aaron's specifically mentions written statements of the doctor. It's right there in the decision of the Court of Appeals, who then says that we don't have to, that a defendant...
But Aaron's also references informal interviews. And in Aaron's, I mean, that doesn't limit defendant to a verbal interview, right?
No, it doesn't limit anything. It doesn't limit what the parties can speak about. It doesn't limit what doctors...
It doesn't limit that, but I think the main point here is the informality of it. You use that document, you use the conversation was an informal conversation, you transferred it into a formal written document, and then you use that document in a formal way. And that's where the issue is. It's really supposed to be almost a convenience, an informal way to speak to the doctor. And I think that's the difference here. You're saying, oh, well, it can be put in a writing, but it was used formally. Not only was it put in the writing, which makes it more formal, it was used in a more formal way. And that's not really the gist of what Aaron's is getting at.
I would respectfully disagree, Justice Kennedy, because
Justice Renwick.
I apologize. If Aaron's is allowing for a written statement to be obtained, what is the difference between a written statement that is not an affidavit and a written statement that is an affidavit? It is a written statement, and that is specifically permitted, not an affidavit. A written statement is specifically allowed by Aaron's. It has been the case since that case came down. So the fact that it was reduced to a sworn statement, as written statement, as opposed to an unsworn written statement, should really have no bearing. This was the doctor's voluntary statement that was provided. He was under no obligation to do so. He did this on his own. And then to provide a second affidavit saying, well, I didn't know what it was for, is of no moment. He's contradicting a sworn statement with another sworn statement, which is routinely disallowed unless a good reason is given, which this isn't.
So, counsel, now this is Justice Kennedy. So,
I apologize.
no, but did the plaintiff provide permission for the affidavit? I mean, I know there was permission for the interview, but what about the affidavit?
The plaintiff is not in a position to deny.
No, that wasn't my question. I think, did the plaintiff give you permission?
By providing an Aaron's authorization, yes.
No, I said a written affidavit. Did they give you permission for that?
Did the plaintiff give my client permission to obtain a written affidavit?
Correct.
No.
Okay, thank you. That's the answer.
Any other questions?
I'm good, thank you. May it please the court, good afternoon, Your Honors. Christopher Della Carpini for the plaintiffs, Mr. and Mrs. Lenigro. Following on counsel's argument about the Aaron's authorization, not only did plaintiffs not give permission in their Aaron's authorization for a written affidavit, defendants never even asked for it. Page 1263 of the record is defendant's notice of discovery and inspection. Item 3, they asked for an authorization pursuant to Aaron's permitting defendant to speak with Dr. Young Kim regarding plaintiff's treatment.
Does the case, and I don't have it right in front of me, say that what they did went above and beyond what Aaron's permits, or is there some wiggle room there?
You talking about Justice Jaffe's order?
No, I'm saying, does the Aaron's case permit the defendant to do what he did in this case by getting an affidavit, or does the Court of Appeals deal with that at all?
It does not, Your Honor, and that's because you look at what Aaron's is talking about. It talks about that there has been a history in New York of informal post-note discovery. Nowhere in that history do they mention affidavits from a treating physician. Then the court recognizes, quite correctly, that in the era of HIPAA, defendants could not even talk to a treating physician without an authorization. Well, which is why Aaron's is usually narrow in scope, right, in order to meet HIPAA requirements. Absolutely. Defendant's position here is that Aaron's authorizes them to get an affidavit from a treating physician regardless of what they asked for and regardless of what the actual authorization authorizes.
There is no place in Aaron's that talks about an affidavit. Whether or not you heard what you heard and then wrote it down and put it in writing is one thing. Getting an affidavit and making it formal in that way is a very different thing than what Aaron's talks about.
Absolutely. It's sworn testimony. It's as formal as you get. Now, on the summary judgment motions here, you could not invent a clearer case of res ipsa loquitur liability than this totally automated elevator. Mr. Lenigro goes to a kiosk in the lobby, he enters his destination floor, a car opens for him, he enters that car, the doors close, and he is at the mercy of the machine. Now, against this obvious inference of negligence, the defendants offer nothing but the affidavit of Mr. Halpern, who admittedly does not know what caused this malfunction. He offers two theories. Maybe it was construction dirt and debris getting into the machinery. Maybe it was a bad CPU in the elevator car itself. Your Honor's, prima facie is not Latin for maybe. This is speculation, and if the defendants cannot offer evidence as to what did cause this malfunction, they have not made a prima facie case
that their negligence did not cause this malfunction.
Does res ipsa apply to a building owner who has ceded all maintenance of elevator service to another company?
WFP certainly did have a service contract with Thyssen. They also had a non-delegable duty. That's settled law. And furthermore, they had notice of this incident. They had a prior incident, an entrapment with this Miss Vat.
Wait, the prior incident is the one that was 2 minutes before on the same day?
That one, yes.
Hard to say they had much opportunity to do much in 2 minutes, but okay.
What did they have an opportunity to do? They had an opportunity to return the elevator car to service because that's what Mr. Jacobs did. And Mr. Jacobs also testified the proper procedure would have been to actually take it out of service and run it up and down for an hour and a half. So while they certainly couldn't have repaired whatever was wrong with this car in that time, they could have taken it out of service, and that certainly would have remedied the dangerous condition. Mr. Lenigro could not have been injured in this elevator car if it had never opened for him.
But it was TEC that was on site at that time and was basically in charge of modernizing these elevators when
That's
this
certainly
happened,
true,
correct?
and the contract with Thyssen is what it is. Nevertheless, the owner has a non-delegable duty. And furthermore, Mr. Rowland.
I understand, but we're talking about notice here, and you're
No.
saying that this happened, this previous incident occurred on the same day, 2 hours before?
Minutes before.
Minutes before.
Yes.
So those minutes were supposed to have placed WFP on notice that there was a problem with this elevator and they should have taken it out of service.
We have evidence that they were put on notice. If you look at the inspection, or the incident report from Brookfield, I believe it is page, just a second. Oh, it's page 412 to 13 in the record, that Mr. Rowland was notified of this incident. So that at least raises an issue of fact on the notice. Not that I can see notice is even necessary.
I want to go back, because you keep saying the owner has a non-delegable duty, but one of the requirements, it may be with respect to other forms of liability, but with respect to res ipsa, one of the elements of res ipsa is that the owner has to have exclusive control. If the owner delegates that by contract and is clear, and I don't hear a dispute that the maintenance company has exclusive responsibility, that is TEC. The contract itself says TEC will be solely responsible for the maintenance of the elevator system. Inasmuch as that has been ceded to that entity, to TEC, why is the owner still responsible?
I concede that WFP tried to give away all responsibility and all duty for this elevator. That doesn't mean they could. The law is clear in this state. The owner has a non-delegable duty.
Okay. I'm just not so sure. I mean, I got to go back to reading Sanchez, and which we decided in 2016, and some of the Court of Appeals in this case with respect to the doctrine of res ipsa, which has a requirement of exclusivity that no longer exists. But
EJ,
that's my research.
May I just ask
Tanya?
a que-
Yes, please.
I just have a question. I just want to know when and how the owner was notified of that accident.
That's page 413. That's the second page of the incident report. It documents that Mr. Rowland was notified.
We good?
Thank you.
Thank you. Okay, you get 4 minutes.
Good afternoon, Your Honors. Daniel Mavrak of Cullen and Dykeman for third-party respondent Structure Tone. I want to jump to the issue of notice. There was no notice to WFP. If you look at the record, they cite to a hearsay accident report filled out by Mr. Rowland, who is a property manager. He admits on page 388 of the record, he had no knowledge of the events of the elevator going out of service. WFP was in fact not notified of the first incident. The call went from the elevator to the security desk that was run by an outside contractor, and they called the elevator
But
company.
did WFP have workers there that were creating debris and that may have interfered with the elevator?
There's no evidence that WFP did any work on the building. A tenant hired a general contractor to do work in their tenant spaces. That was not within WFP's purview.
Furthermore, the car was never put out of service. There's an idea here in the papers from the plaintiff that somehow the car was put back in service, taken out and put back in. If you look at the testimony from every single one of these technicians, all the people who worked for TKE, they say that when the term released is used, that means the person who was entrapped got out of the elevator. What happened is the technician was sent to go check this elevator out at 8:28. He responded on his radio that he was going there, but he didn't get there, as the court pointed out, until after the second accident. When he got there, there was no one in the elevator, and the elevator was working normally. So there is no chain of events in any of the testimony that puts the building itself on notice that there was an incident, let alone that there was any response to it, because there wasn't, in fact, a response to it before the second incident happened. He couldn't have gotten there in 2 minutes. That was the testimony of one of the witnesses who said, and I'll quote this, he said, unless he had a Superman cape on, how's he going to get there in 2 minutes? And that's on page 588 of the record. It's a 25-story building. There's no way the technician could get there in 2 minutes, respond, turn off the elevator, and turn it back on again, and the record confirms that didn't happen. If there's no further questions?
Thank you.
Just very briefly, on the issue of notice and the perception that there are two incidents, it should be pointed out the person who was purportedly involved in the first incident has denied in a deposition any knowledge of any incident on any elevator. The computer log on the elevator only registered one incident. ThyssenKrupp's records only registered one incident. The only quote-unquote evidence that an initial incident took place minutes before plaintiffs is a single piece of paper that is completely unsubstantiated by any witness in this case. Nobody can say that anything in there is true. The person allegedly involved says it's not true. As to notice, our expert, yes, says that this either happened because of a defective CPU or that because of construction debris that interfered with the interlock on the elevator door, causing the stoppage of the elevator temporarily and then reconnecting, allowing it to go to the intended floor. Pat Carriger, the plaintiff's expert, provides nothing except for, well, it occurred because of what is said on the computer log, which was an interlock got clipped, and that ThyssenKrupp didn't do enough maintenance on an elevator that had just been installed 3 weeks earlier. And there was nothing in between that date and the date of the incident to indicate, that any relative defect. Violations issued by the Department of Buildings at a Cat 1 test are all irrelevant, a fact not contradicted by their expert. They have nothing to do with this case. So I respectfully argue there is no negligence here. There's no notice, and res ipsa does not apply because this could have happened in the absence of any negligence by the defendants. If there are no questions.
Thank you. Okay, you got 2 minutes.
Thank you, Your Honors. For the last word on the notice issue, not that we're conceding that notice was required to impose the non-delegable duty. I direct you to page 413 of the record where the note says that approximately 0828 hours, Ms. Vatman contacted security about her incident. The car was released at 0830 hours. Now, on the issues of the second affidavit that plaintiffs obtained from Dr. Kim, there's no basis for excluding a non-party witness's subsequent statement just because it contradicted an earlier one, not that that one is even admissible as we've discussed. As to this,
Just with respect to the prior incident, did it involve a free fall and an abrupt stop as this incident, or was it something totally unrelated to that?
the note indicates an entrapment, although it is interesting that the incident happens in the exact same journey, in the exact same car, from the 16th floor to the 10th. There are problems with that elevator car on the 10th floor. In Ms. Vatman's case, it manifested in an entrapment. In Mr. Lenigro's case, it manifested in a sudden stop.
Okay.
As to the subpoena for Dr. Kim's testimony, defendants never even moved for post-note discovery. That should settle that issue. Should this court reinstate the claims against WFP, there's no reason not to grant the motion for severance. There's no questions of fact for the trial court to resolve. And as for the spoliation charge, we have all the elements of spoliation here. The defendants controlled the CPU. When they knew about Mr. Lanigro's accident, they removed it. They said it was defective. They got rid of it. And now their expert comes in and says that that CPU may have been the cause of this accident rather than any negligence on their part. That is very convenient, and it has all the circumstances that militate in favor of a spoliation charge.
And there's no question that litigation was reasonably anticipated.
They knew that Mr. Lanigro had been injured. They knew he'd gone to the hospital. They knew he'd sought medical treatment, and they investigated, and they say they found it was defective. And they throw it out, and now they want to blame it.
How long after the accident did they determine that the CPU may have been the reason for the accident?
I believe it was later that day. I think they investigated it that day.
Okay, good. Thank you. Thank you all.
30 seconds to address the spoliation issue.
You didn't address it on the 2 minutes that I gave you. I mean, you can't possibly address every issue in this case. It's pretty extensive, so thank you all. Okay, Pacific Alliance versus Wong. Justice Kopnick has recused from this case.
Good afternoon. May it please the court, Ira Matetsky for the appellant, Kwok. After this appeal was filed, the motion court entered another order, which our adversary put before the court in NICEF document number 12. They've discussed it in their opposition brief. We discussed it in our reply brief. And in that order, the motion court acknowledged that it could not hold Mr. Kwok in contempt until it held an evidentiary hearing on one of the most disputed factual issues in the case, which is whether Mr. Kwok, in fact, owns or controls, but more specifically owns, this boat. The motion court said the court cannot enter a final order of contempt on the present record. Because the ownership of the restrained asset, the Lady May, is disputed, the court would need to hold an evidentiary hearing to determine whether a final order of contempt is appropriate. It's acknowledged that not only has an evidentiary hearing never been conducted, but in fact there really has been no fact-finding at all by Justice Ostrager on whether Mr. Kwok owns or controls this.
Well, there have been some findings, right? Justice Ostrager found that that Kwok, quote, attempted to mislead the court, play shell games with his assets.
Those are conclusions, Your Honor. They are obviously conclusions that are unfavorable to
and
my...
violated the spirit of the court orders.
Those
are his opinion of your client's conduct.
That's his personal opinion, but it is unsupported by any specific findings of fact based on an evidentiary record.
Didn't Mr. Kwok's counsel ask the court whether the yacht could be moved out of New York waters? I mean, didn't that, I mean, why would you want to ask the question if you have no control over it? Doesn't that indicate at least some that he has an ownership interest in that yacht or has some degree of control over it? I mean, why else is he interested in whether he can move the yacht out of New York waters?
Your Honor, I went back and looked at the record in preparing for this argument. In fact, if you look at what counsel said, and counsel obviously was not aware when he was addressing the court at this hearing in November that the boat had already been moved. But what counsel actually said is, I want to inform the court that this yacht is relocated every year. He didn't say in so many, in order to avoid any dispute, far from establishing that this order was unambiguous, and it's uncontroverted that an unambiguous clear order is a prerequisite for contempt, the fact that counsel felt the need to bring this to the court's attention reflected the...
So the yacht had been moved prior to October 15 of 2020?
Yes, the yacht had been moved. According to the affidavit of the boat captain, the yacht had been moved from New York at least to Florida. I think it was the first week in October. Subsequently, it was moved from Florida to somewhere in the Caribbean, I believe it was.
Because that wasn't clear in the telephone conference that was held on October 15, right? Because the court is still at that time concluding that Quark had previously claimed ownership of the $27 million yacht, right?
The court notes that there are some statements by Mr. Kwok, which he was never given an opportunity to explain in a hearing, which our adversary could have presented at the hearing as potentially some evidence of ownership. But there was no finding of fact that there was ownership. As I say, Judge Ostrager acknowledged that. And the cases are legion, cited in both of our briefs, that where a disputed issue of fact arises in the context of a contempt adjudication, a party is entitled to an evidentiary hearing to determine it, that issue. Here we had both the ownership issue and the control issue, among others, not having been, as I say, by the judge's own admission, not having been the subject of fact-finding. There were several other issues, grounds for reversal presented in our brief, but I'll briefly...
Aren't there cases that do not require an evidentiary hearing before finding of contempt?
Yes.
All you need is clear and convincing evidence, right? Which can be met by, say, a party's admission that he owns the yacht.
Well, in this case, the evidence surveyed in our brief was far from clear and convincing. I think there was a translation of a snippet from a YouTube video.
I mean, we'll be the judge of
quality
that.
of evidence. But there was also evidence that in the record that the yacht is in fact owned by not by Mr. Kwok, but by a corporation owned by somebody else.
In fact,
By his daughter. Don't say somebody else. His daughter, right?
A corporation that's ultimately owned by his daughter.
In fact, I think there was a video or something in the record. There's something about a video that Quoke posted bragging that he purchased the yacht and put it in his daughter's name solely to avoid creditors.
Your Honor, I apologize. I couldn't hear every word of that, but I think I got the gist. And the answer is that this was a clearly disputed issue of fact. There should have been, by the judge's own admission, an evidentiary hearing before the finding. And the one other point, and maybe I'll get to it when I stand up again, is that there was no clear and unambiguous order of the court that could have given rise to contempt in the first place.
Well, counsel, now, wasn't there a November 12th conference with the court? And the court made it clear that if you wanted to move the yacht, you had to make a motion on notice. So can it be said that you were on notice, you had to make a motion, that didn't happen? You knew about the order and you disobeyed it.
It had already been moved by then, Your Honor. It had already been moved by that time. Even assuming arguendo that order...
Why hasn't there been where's the yacht now?
The record doesn't indicate where it is now, but I have no reason to
It's not in New York.
I have no evidence that it's been brought back. That's correct.
Okay, so we're not talking about winterizing, right? We had June, July, August. Pretty warm in New York.
The evidence that was presented before the court was that the yacht needed to be removed, and it was removed before, certainly before November.
Needed to be removed because
of the yearly routine for both winterizing the yacht as well as the immigration status, and there's a requirement.
Did winter come up as one of the reasons why it needed to be moved to a warmer climate?
The fact that the winter was approaching is definitely one reason. The legal requirements for the registry of the yacht was the other reason why it needed to be removed first to a warmer
Well,
climate.
how long did that take? Because the captain said that it always came back.
Well,
but interestingly, it didn't come back even after the warm months. That's the point.
But that's not the contempt. That's not the contempt that was found. In order for there to be a finding of contempt, there needs to be an evidentiary determination, not a gut feeling by the judge, that Mr. Kwok both owns and controls the yacht, and there needs to be a clear and unambiguous order that was found. The order that the judge found was violated was not something that was said on a transcript later on, but was the October 15th order, which says you are not to sell, transfer, assign, or interfere with the boat. That's about title. That's about ownership. My adversary has cited no case either under CPLR 5229 or 5222 where the vague word interference has been held by clearly and unambiguously, by clear and convincing evidence, preclude moving an asset from one place to another.
Counsel, why wasn't the yacht returned in May of this year? Why wasn't the yacht returned in May?
Since my client does not own or control the yacht, I can't answer that question.
Okay, thank you.
Counsel, has Mr. Kwok ever claimed ownership of this yacht?
Yes.
How many times has he done that?
Filed a complaint in September of 2020 in New York State Court where he claimed in several places in the complaint that it was his yacht. There's also a YouTube video where he's talking about it being his yacht. And one point where I wanted to start, one point I wanted to make clear was that there is a distinction between control and ownership. Control is relevant because somebody has to be able to comply with a court order before they're held in contempt of that order. And the fact that Mr. Kwok controls the yacht and the Sherry Netherland apartment was found at the time of the October 15th order. This is what the court said in the October 15th transcript, which is incorporated by reference into the order itself. Mr. Kwok and any entities that he directly or indirectly controls are restrained from alienating or transferring any property that Mr. Kwok has a direct or indirect interest in, including most specifically the apartment at the Sherry Netherland Hotel. And also
How do we determine whether he indirectly or directly controls the yacht?
Well, so I think the trial court already determined that in the October 15th restraining order, and if Mr. Kwok thought that was wrong, he had a few options. He could have appealed that order. He could have gone back to the judge and said, Judge, I can't comply with this order because I don't control the yacht. But
So that was the nature of the teleconference on the 15th of October, where the court found that Mr. Kwok had attempted to mislead the court and play shell games, etc.
Exactly. That was all part of the same order. And if Mr. Kwok thought that the premise of that whole restraining order was wrong, he could have appealed or he could have gone back to the judge. The one thing you absolutely cannot do is try to collaterally attack the original order by fighting out the premise of that order when you're being held in contempt. I mean,
that October 15th order was not appealed, correct?
That October 15th order was not appealed. And not only did Mr. Kwok not complain, I can't comply with this order, as Your Honor noted earlier, on November 12th, he went back to the court and said, by the way, I just wanted to make sure that when we move the boat for licensing purposes to the BVI, that wouldn't be in violation of the order. And the judge said, of course it would be in violation of the order. You better move for permission to do that. And instead of doing that, Mr. Kwok kept the boat outside the jurisdiction. The captain said, in the ordinary course, I'm quoting from 101 of the record, in the ordinary course, the Lady May would return to New York sometime in May 2021. So when Justice Ostrager issued this conditional order of contempt, I assume he thought that there wasn't going to be any actual sanction at the end because the boat would return in May. So he said, so long as the boat returns in May, you're not going to have to pay a single dollar. And instead of returning in May, as it was supposed to do in the ordinary course, somehow it ended up in Europe. And as far as we know, it's still there. So, you know, it's true that Justice Ostrager held in July, after we said, look, he's violated the order. There was a conditional contempt order. Now he's violated the condition. You should enter a final order of contempt.
Violating it by not bringing the yacht on the 21st.
Exactly, by not bringing back the yacht by May. And Justice Ostrager said, you know what? You're right. He's violated a court order, but I'm not going to actually issue a final contempt sanction until I find that he actually owns the boat. And the reason that's relevant is because we can only collect the boat to satisfy the judgment if he owns it, which is a separate issue from control. And the judge, in his discretion, found, I'm not going to find the requisite prejudice. I'm not actually going to hold him in contempt unless I find that you could actually collect against that asset. We thought that was wrong, so the only one that's got any right to complain about that is us, right? They have no right to complain about the fact that Justice Ostrager, at the end of the day, agreed with them, but that certainly doesn't undermine his original exercise of discretion in just being fed up with the fact that Mr. Kwok keeps on violating an extremely clear court order, and then he could have held him in contempt right there, right? But instead, it was conditional. He said, look, return the boat when you said it's coming back anyway.
So even after it was acknowledged that, listen, the boat is not here by May 21st, he still had time he still had June, July, and
Yeah.
August.
Yeah, of course. I mean, he could have returned it. He should have returned it by May because that's when he told him he was coming back anyway. But he could have returned it at any time and cut off the sanction. You know, they complain about the size of the sanction, but the only reason the sanction is so big is because he's just not complying with the order. You know, there's a case that we cite, New York City Transit Authority against the Transportation Workers Union of America. It's a second department case where a union violates an injunction to stop a strike. The judge holds them in contempt, and he says, there's a sanction of $1 million a day. And the ultimate sanction was $1 million because they stopped after a day. You know, well, if they had gone for a year, then the sanction would have been $365 million, but it wouldn't have been an abuse of discretion because it grew so large just because they flagrantly violated the order. But that's their argument here, right?
Yeah.
The sanction should have been $0, and instead it's grown to a large amount.
Well, it's
because they
pretty
won't
close
comply.
to the value of the boat now, right? 500,000 a day is $3.5 million a week times.
Let's call it a yacht and keep the value up there.
Yeah, that's right. That's right. Exactly. I mean, it is getting close. I don't know
Boat,
exactly.
yeah.
Yeah, it's a big boat. It's an expensive boat, and you know, I don't know what the actual. I haven't calculated, but it's somewhere up there. But the only reason it's grown that long is because he won't comply. He could have cut it off at 0, Your Honor.
Okay, thank you.
Thank you.
Your Honors, he couldn't cuff it off at 0. He couldn't cut it off at any amount unless he controlled and owned the boat. Precisely the issue that we're entitled to, we respectfully submit.
Why wasn't that raised on October 15th, though?
Because on October 15th, there was an order. Well, first of all, on October 15th, counsel wasn't aware the boat had already been moved. But more importantly, the order directs
So
Mr.
did you counsel tell that to Justice Ostrager?
It was brought to his attention, I think, by the other
Right.
side first.
Didn't you ask him for permission to move the boat?
I'll repeat the answer I gave earlier, Your Honor, which is that it was not so much a question of asking permission as advising the court that as a matter of the ordinary routine, the boat was going to be moved. And the court said, don't do that without.
The reason I asked it for a second time is because I didn't like the answer the first time. But, okay.
By the time, as I said earlier, the fact that question was asked shows that the order was ambiguous, not that it was unambiguous. There was not a single case reported anywhere where the word interference has been interpreted to prevent relocating a physical asset. There was not a clear order.
I just, you know, it just seems to me that, you know, given how I believe court orders are sacrosanct and we need to obey it, particularly in a society under the rule of law. But if I have a court that's telling me, counsel, you're misleading the court, you know, you're playing shell games, you're violating the spirit of all the prior orders that I've issued, at the very least, I would have said, Your Honor, you know, the underlying basis of the order is that I cannot transfer it. By the way, the boat is not in New York, but that didn't come up.
Well, neither Pacific nor the judge relied on the word transfer as the basis for contempt. The word that was used was interference. There needs to be a clear and unambiguous order.
You don't think moving it to Florida and the Virgin Islands is interference?
There, in all the 200-plus years of judgment enforcement in this state, there is not a single case in which moving an asset from one place to another was treated as an interference for purposes of a restraining notice or for purposes
outside the power of the court to give the parties over which the court has jurisdiction the relief that they seek.
There might have been other means by which counsel could have made that request, a specific request. Don't allow him to move the boat. Don't allow him to move the vessel. That would have been a clear and unambiguous request. The order also applied to a condominium apartment, which clearly wasn't going to be moved. Physically relocating the asset from one place to another.
Within the jurisdiction of the court, right?
Right, but it was not the idea that an asset might be moved from one place to another simply is not what a 5222 or 29.
Well, it has to contemplate whether you need to answer the first question, whether it's movable or not. A yacht is separate than a condo, right?
Right, and if they wanted it not to move, they could have asked for it not to be moved.
Okay, all right. Thank you. Thank you both.
Thank you, Ron.
Liberty Square. Yo voy a gozar escribiéndolo.
Good afternoon, Your Honors.
Good afternoon.
My name is Yoram Nachamovsky. I'm the attorney for Liberty Square. And the question that we have from the beginning is, what did we buy? If we bought Lot 35 only, then the courthouse itself, which extends over the edges of Lot 35, didn't we buy that courthouse?
Yeah,
which-
how do we determine what you bought? Right? I mean, generally, the boundaries associated with, if I'm going to buy something from somebody, usually that item well, let's stick to real property, right?
Yes.
Meets and bounds, you get measurements, you know exactly what you're buying. Did you complain at that time that there are no meets and bounds?
Absolutely, Your Honor.
And what was the response then?
The response was that we don't have meets and bounds worked out. Nobody has done the engineering to give us meets and bounds because this was a courthouse, the younger
Right.
sister of this courthouse. So nobody had meets and bounds for this because it wasn't really a house that was being sold where it would be 100 by 20 or something like that.
Right.
So the courthouse, when it was built in the early 1900s,
But was it at least an explanation about, you know, do I have access to a loading dock? Or do I have access to 161st Street? Or do I have access to?
well, when I asked, I was at the closing, when I asked for that, and my client put in an affidavit about it. When I asked, well, tell me what I bought, show me what I've got. The answer was, I'm going to give you a tax map, which is what was described in the auction brochure. The tax map was described in the auction brochure, and there's a picture of the courthouse, which is a huge courthouse,
Right.
you know, a little bigger than this one, actually.
But you also accepted the city's attorney just basically taking a pencil and, I mean, I just found that to be the most unusual thing.
Your Honor, I agree, very unusual. I've been practicing a long time. It was the most unusual closing. However, the city said to us, if you don't close now, we're not going to sell it to you, and we're going to put it back up for auction, because they had a buyer that they wanted to buy the property. They were steering everybody on this particular deal. And we said, no, we won the bid, we want the property. Now, the way we saw it, the way my client saw it, obviously I'm not an owner, I may speak as we, but it's not me.
Gotcha.
When my clients bought this, it was part of a rehabilitation project. There was a ULURP going on in the Bronx. They were going to redo all these, you know, areas, and the city was going to use this courthouse, the courthouse that my clients bought, as the centerpiece of that whole rehabilitation project. But when they went into the courthouse and estimated what it would cost, they had estimations of over $80 million. When they saw $80 million, they said, we don't want to be involved in repairing it. So even though the price was technically $300,000 and on the books $255 was the estimated value that you'll see in the papers, the real price is the millions and millions of dollars that would needed to rehabilitate the courthouse. Since it's a landmark, there are no other entrances that could be made to the courthouse. I noticed as I walked in here, the two lower lobby entrances are on the outside over here on the street, so that in case there has to be loading, the truck pulls up, things go down into the lower lobby, and that's how this courthouse gets its, you know, intake and outtake of materials. In the Bronx, the three entrances that are accessible to the streets are for people, pedestrian entrances. They don't go down to the bottom at all. They only go up. That's for the people to come into the courthouse. The lower entrances, the 5 entrances, are all on the 512 East 161st Street entrance. The deed itself, Your Honor, provides not just a lot, but it also provides the address of the courthouse. And as it says in the papers, there was a full-scale picture. That is the historic entrance, is the courthouse entrance on 161st Street. Now, the city and the DOE and want to argue that you don't get any part of entrance on 161st Street. In the,
So let me see if I
yes.
understand this. So you're saying because he lists, the deed lists the address of the courthouse, you bought the property that's part of the courthouse?
Absolutely. Absolutely.
And that includes the entrance?
That includes not just the entrances, but it
The
includes
loading.
the vaults that are underneath. It includes the two bullocks at the end of the courthouse. It has these, huge bullocks that are like corners to the courthouse. And those extend out into the street,
But the idea was, 161st Street, where the dock is on 161st Street?
Yes, that's the only loading dock for this courthouse.
Okay, and so that was a street that any car or anything else could traverse. When this was purchased, that was closed so that then only buses could traverse there. Is that right?
No, it was an open street. It was running until the time that they closed off the fencing in 2010, and that's exactly when we brought the lawsuit. Until that time, the street was open, operational.
So buses and any sort of cars could traverse there as well?
Anybody, our trucks were going there. The reason that the lawsuit was brought was because we had, when I say we again, it's not me, it's my client, had huge steel beams that had to be brought in to the building because the building was declared unsafe. So the beams were tremendous. They had to be brought in by truck on 161st Street and lifted up to the courthouse so they can strengthen the foundations of the courthouse, the upper floors. In the meantime,
So otherwise, you would have no access to...
No, you can't carry them through the front door. It's not like, it's impossible to
In
carry
the
steel
circled,
beams.
in the circled addendum, in the tax paper that's circled, is there more than the building and 161st Street that's circled?
Yes. First of all, there's more than the building. My understanding was that she was trying to indicate the easements, but she wasn't an artist. She was just a lawyer like us and putting her diagram of what she felt. Does it extend beyond? It may extend beyond what we have. It may not. But I think that it's a question of fact. No doubt that there's a question of fact. And this case has not gone to any sort of trial. It has not even had discovery in 11 years.
So your concern is specifically for 161st Street or beyond?
I'm sorry, I couldn't hear that.
Your concern is for 161st Street or beyond?
My concern is that we have a loading dock, that we have access
That's
to 5
161st
entrances.
Street, isn't it?
Beyond 161st Street. Beyond that, I don't care. I am also concerned about the fact that the city did not protect us from did not protect the landmark. This is a landmark building. In the brochure, where they put in the auction brochure, they prevented us from doing any work indicating to us as a warning that this is a landmark building, and you can't just do anything you want. You have to comply with loading, with landmark and everything else. But then on the other hand, the people that they sold it to did not comply with landmark and were building closer than than they were allowed to build to this building, obscuring parts of the building. And frankly, I never thought I would have to argue this case. It's certainly not this long.
Well, okay. We can ask you questions till tomorrow, because there's so much stuff in here that is perplexing.
It's perplexing to me. The one thing I would like to point out is, the deed itself was filed together with that drawing. That drawing, if you look at the marks on the drawing itself by the deed, it says they're in subsequent order, 14, 15, and 16. That's part of it. There are 4 pages to the deed. That was one of the pages. It's also, the address is listed in the title report that the city made us get. And then besides that, the amazing thing is that they filed the landmark requirements for building next to a landmark. They filed that 2 years after the time that they were supposed to. And in the meantime, the city was on notice because there was a letter in there to Ted Weinstein. We have a Henry Weinstein, they have a Ted Weinstein. And there was a letter there to Ted Weinstein saying, please make sure that make sure we're protected, make sure that you take care. We are also rehabilitating a building for this project. In other words, there are those people rehabilitating a building and us. and they sold the street for $1. Do you think my client would have given $1 to the city to buy the street?
Well, they wanted to sell it back to you, right?
Well, after they,
That's a different story. So, thank you, counsel. Let me
Thank
hear
you, Your
from the
Honor.
other side. Increíble. Increíble.
May it please the court, Jameson Davies for the municipal respondents. Given the questions, I would like to give the court the simplest way out, and that is that this case is time barred. The parties don't dispute that there's a 3-year statute of limitations that applies. The property was sold to the Doe Fund's predecessor in 2007. This action was not brought until 2011, and it's plainly time barred. The only argument that they raise is equitable estoppel, but they can't demonstrate any action that the city took to conceal the sale. It went through 4 public hearings that were published in the city record. There was a ULURP hearing, there was a city council hearing, there was a mayoral hearing, and a DCP hearing, all of which were public. And there's even assuming that they didn't realize it at the time, in their brief, they can see that as of 2010, if you look at pages 11 and 12 of their brief, that they knew that there was disputed claims as to the city street, and they didn't bring the claim until March of 2011. And the case law indicates that once even if you have equitable estoppel, which they don't, once you're aware of the concealment, which they were at the latest sometime in 2010, you have to promptly bring your claim, which they did not. So the simplest way to resolve this case is on statute of limitations. It's plainly time barred. Even assuming it's not time barred, the deed is unambiguous. It conveys only tax lot 35 to Liberty Square, and the irregularly shaped drawing does not vary the terms of the deed. The deed, although it refers to the tax map, it's actually making a more technical reference to the tax map of the city of New York as it existed on a certain date. And the tax map is a formal thing, and it can only be changed through a specific process. It's not referring to that hand-drawn tax map that was attached and filed by Liberty with the deed. There's no indication that that was the map that they're referring to. They're referring to the tax map of the city of New York, which is a formal legal, a term of art that refers to the actual lots across New York City. I also want to clarify one thing on the point the council was making about whether the city.
What about the one of the claims is an easement by necessity? They're claiming that maybe they have an easement by necessity because they absolutely need to use this loading dock. It's a landmark building. They can't build another loading dock. They can't get anything in and out of the building without the use of this. It doesn't make any sense. Why is that at least not asserting a claim for an equitable easement, or an easement by necessity is what I mean?
Sure, a couple points to that, Your Honor. First off, at this point, the city has a pretty little interest in whether there's an easement, so I might leave a fuller defense on that point to the co-respondents. But I would say that there's no case that is held that a loading dock is the kind of easement by necessity that can be alleged. It usually, almost always, is in the case of a landlocked.
But isn't that an issue of fact? We don't know what they need to take into the courthouse. Clearly, those steel beams that they needed to take in to do work in the courthouse, I mean, they need to get them in somehow, right? They need to pay the other defendants?
That may be the case. I think necessity is a question of law that the court can determine, and it has been determined, I think, on a legal basis in a lot of those cases.
Well, it's kind of hard to do that at this stage of the litigation, right?
Right. I'd also note that there's no allegation. They make the claim that it's a landmark building, but you can't apply to the Landmarks Commission for variances and things
But
like that.
why should they have to do that?
Well, I think to show that it is, in fact, a necessity, they have to show that there is no other possible way that they can make use of their property without an easement. I think that's...
Well, if it's the only, okay.
I'm sorry, Your Honor?
I mean, it's the only loading dock. There's no question about that. That's easy to determine, right? It's the only loading dock in a major building that was built with a front entrance, and that was the back entrance. Now they don't have access to it. You just said, well, maybe they have to pay somebody to get access to the street of the building that was there initially that they bought first. Does that make sense?
Well, I would say that they bought the building, but they did not buy the street, and I think that's clear. And they're aware.
They bought the building without the street, but they have this addendum. Anyway, we're going in circles. You can finish your argument.
Sure.
I'm not going to interrupt.
Thank you, Your Honor. The other point I just want to make on their argument that the city failed to somehow require these filings, that was not argued, as we point out in our brief. If you look to note 4 on the last page of our brief, that was not argued in the appellant's opening brief, and that's forfeit. And even if it wasn't, the Supreme Court correctly found that there was no special duty that was alleged, and there was no private right of action under this under the statute that allows them to bring this claim against the city for any alleged failure to require the filing of these particular plans. But primarily it's forfeit, as we point out in our brief. And I would also just bring up that the city attorney did not have the authority to dispose of anything more than the tax lot. There's really no argument that they can make that the city somehow conveyed the idea that the city's attorney had the authority to dispose of more property than was up for sale at the auction, and that there's the case law is clear.
I'm sorry, what was the impediment to you selling a landmark building that contains an address, meets and bounds? I mean, everybody, the tax transcript would indicate what the place is, where it is. What prevents you from conveying it? At the very least, the dock that they're going to need to use for the property that they're buying from you.
I don't know that there would be anything that would prevent them from conveying it, but I think it was pretty clear from the auction brochure, the title insurance, that was not what was being conveyed. The property is being sold as is, and it's the same idea.
What was up with that circle that you drew?
I think it's completely unclear what that means, but it's not the kind of evidence that can carry
which is why at a 3211 posture, like you want us to make findings as a matter of law about what took place that long ago, and to basically interpret in your favor the meaning as a matter of law, that circle you drew when they didn't want to close without some indication from you.
Well, if I may, just 2 quick points on that. First is that it cannot vary the unambiguous terms of the deed, which are contained in the text of the executed document. But secondly, this is all besides the point because the case is clearly beyond the statute of limitations, and there's just no response to that.
Okay, but that doesn't pertain to the easement by necessity that they can assert against Boricua.
Correct. That's just as the inverse condemnation claim.
Yeah. The city, yeah. Thank you.
Thank you, Your Honors.
Good afternoon, Your Honors. William O'Connell, Goldberg Segala, representing the Doe Fund and Boricua Village. Your Honors, it's our position that the lower court did properly grant motion to dismiss based on documentary evidence, and there's a reason for it, and it's because this was real property. This was not some other contract. There are special rules for real property. Judge Sachs recognized that 10 years ago in the Torres case, and there are specific rules about writings. One of them, obviously, the statute of frauds. A property contract to convey an interest has to be in writing. Second, extrinsic evidence cannot vary or contradict an unambiguous deed. And third, when a general merger clause might not, with a general merger clause, you can introduce parole evidence to show fraud.
You mentioned an unambiguous deed, but wasn't this deed somewhat unusual because it didn't have the meets and bounds, it just has the address, and usually that would have been there to make this clearer so you wouldn't be here today?
Could be unusual, but it was unambiguous.
What's unambiguous about it if it doesn't have, if it just had the lot and I guess the block and the lot, but not more?
Respectfully, Judge, it had a block, it had a lot number, it referred to the New York City tax map, which is a diagram that shows that lot there, and that was consistent also with the auction brochure, which described it in the exact same way, the block and the lot number and the address and the title insurance.
Wait, does the tax map you're talking about is the one with the circle on it?
No, that's not what I'm referring
to. Oh,
to.
okay.
The council is relying here on a tax map that has a circle on it. I don't know how that got a circle on it. No, none of us.
Well, he knows he was there.
I'm sorry?
He says he knows he was there.
Well, he says he was there, and oral statements, oral variances from an unambiguous document.
Beyond that, you have an address. The address includes the loading dock area, doesn't it?
The address includes the loading dock? Is that your question, Your Honor?
That's my question.
Yes. There is a loading dock in this building, and it's not a necessity. There are multiple entrances around other sides of the courthouse, And they can get.
It's not a necessity that the building that's sold with the address that's unambiguous is sold in a way that the person can't get to the part of the building. That's what you're saying. It's clear as day because the building address is there. But part of the building is that loading dock that they can't get to. And you're saying, well, that's okay, because there are other entrances.
No, I'm saying they can get to it. There are entrances on the other sides of the street. The side of 161st Street is open. In fact, as you know from reading this, it's an open pathway to the public. So it's not perhaps vehicle accessible, which could come around the side of the building, and they could bring materials along the sidewalk and into the courthouse. Not ideal, but they knew what they were buying as is, and it was listed right that way. So, in fact, if I were at a closing and the city said to me, well, we don't have meets and bounds, so sorry, and then they just drew a circle on it, I'd say, well, aren't you going to put that the circle means something, like it includes exterior and loading dock and things like that? And then again, if that happened, I would probably include it in my complaint. It is nowhere in counsel's complaint, any mention of a circle or anything else. It's only in motion papers and affidavits years later. So I'm just saying, on the face of the document itself, it is unambiguous. Thank you, Your Honor, and there's no easements. Thank you.
Thank you.
I can't locate it right now, but I know that in the auction brochure, Your Honors, it says as is in terms of whether there are tenants involved. That's what the as is, in quotation marks, is defined in the auction brochure, which is one of the exhibits here. Obviously, I feel that the courthouse was sold as a whole, as a building, as a living structure that had to be used the way it was intended, because it was a work of art, it was landmarked, and I think that the loading dock is an essential part of that work of art. It is the entry point, and the entrances that he's talking about, as I indicated earlier, on the sides of the building are entrances that go up. They're entrances for people to go upstairs to the 5 floors above. They are not entrances to go down, and to go down is where all the supplies of the building are and are needed. Thank you very much, Your Honors.
Thank you. Thank you all. Venecia? You're gonna have fun with that.
I don't know where my adversary is.
What the city did is like, I just can't believe it. And they had the guy over a barrel. So see, they were gonna sell it to somebody else. That's why he said, oh, I gotta buy it, draw a circle.
May it please the court, Your Honors. My name is Scott Singer, and I represent the plaintiff appellant in this case. They say a picture is worth 1,000 words. So how much is a picture and a video worth? In this case,
a lot.
Still 1,000.
Well, we got the pictures, so.
You didn't get the video?
Yes,
No,
no, we
got the
did, yes,
pictures.
yes, we
As
have
long as
it.
you got the video, because I think the video is in many ways even more significant. So I think if you look at the picture and the video, there was no cleared path. Essentially the entire roof was covered with ice. The plaintiff slipped on the ice. It's a very straightforward case, I believe. And I don't think there's any bona fide dispute as to the facts. The witness for the defendants, Jason Stewart, took the photograph, the still photograph. He was asked about it at deposition. He says, "Do you see any cleared path here?" He answered no. And if you look at because you've seen the video and you've seen the photograph, the only place where there was arguably a path at all was precisely the place where the accident took place. The plaintiff's foreman, Adam Romano, explained in his deposition testimony.
So you think that alone, or there's more, Mr. Singer, that renders Stewart's testimony incredible as a matter of law?
Well, I'm not really sure what Mr. Stewart is saying. I mean, he's saying he saw some people clearing the path. Maybe he did, or maybe he didn't. But he was actually very candid in his deposition testimony. He says, I don't know if there was ice. I don't know where the snow was. I don't know if they were putting ice melt down. I don't know if they were clearing. I don't know if they were maintaining a path. He didn't know anything. And so I can't say he was, whether it's incredible, not incredible, I don't really know what he's saying, but for sure, there wasn't a path. And you can look at the photograph and the video over and over again. There's no cleared path there, certainly not a 6 to 8 foot wide cleared path. So in those circumstances, you can't be off the path if there is no path. It looks to me like Mr. Venezia was walking in the most direct way he could. And it looked like that was, to the extent that there was any kind of path, that's where he was walking.
I'm sorry, go ahead.
Did Mr. Romano testify that the photo actually depicted less ice than there was at the time of the accident because some of it had melted?
Yes, he did. There was about
did he testify to that?
Yeah, there was about a 2-hour gap or an hour or 2-hour gap. The accident took place at 10:15. He said it was at lunchtime when they actually went up and photographed it. But as I say, if you look at what Mr. Stewart said in his testimony, he says, there's no path there. So there still wasn't a path there. You could see there was ice all around the area, and that much was undisputed. So I think in these circumstances, there was certainly a violation of Section 23(1.7b as a matter of law, and hence Labor Law 241.
Mr. Singer, is there a dispute with respect to where the accident actually take place?
Actually, no, there isn't a dispute. Because if you look at it, and in preparing for the argument today, I took a look at the photograph. The photograph, remember, was taken by Mr. Stewart. He took it because that's where he told the accident was. And then they asked, during his deposition testimony, Adam Romano, to pinpoint where it was. It was right smack in the middle of that photograph. So everybody knows where the accident took place. It was marked, and it was in the photograph that Mr. Stewart took. So it's very clear where it took place. You can see that little hose. If you're looking through the video, you can see a curlicue of the hose, and that's where it was. I mean, when they marked up the roof blueprint, he put it some distance, Mr. Stewart put it some distance away from where Adam Romano had it, but it was essentially the same area. And you could see very clearly, if you put together the video and the photograph and the testimony, the marking that were put on the photograph, you know exactly where it was, and it was not a path, and there was no path there. So we ask that the court grant us summary judgment on our 241-6 and Section 200 claims.
Thank you, Mr. Singer.
Thank you.
Good afternoon, Your Honors. May it please the court, Hillary Simon of Kennedy's for the defendants, LTS and JRM.
Was there a clear path?
Yes. Well, there is conflicting testimony.
Well, did you look at the picture that's worth 1,000 words? I looked at it. Where was the path?
Yes, so the picture and the video they weren't taken at the same time that the accident happened. First of all, I'll just address the video. It was taken several hours before the accident, by Adam Romano, an interested witness, before they even began work on the roof, and he admitted that he never reported the conditions to anyone.
So what time? You say several hours. What time?
I believe that the incident happened just prior to lunchtime, and the video
It happened around 10 o'clock. That's when the other pictures were taken, just prior to lunchtime.
No, the pictures were taken just after lunchtime, I believe, and the video was taken before they began work for the day.
I have that the slip and fall happened at about 9:30 a.m.
Well, the video was taken before they began work for that day.
Yes,
So,
that's what I'm asking you. What time was the video taken?
Adam Romano took the video. I believe it was taken at around 6 a.m., 7 a.m.
You're saying he's an interested party? I mean, what makes him, he's the foreman of the area, right? He's concerned about the safety of it and the fact that they've been compelled to work under those circumstances? What makes it interesting?
Well, he's plaintiff's friend, first of all, and he
But
was
he
also
works
the
for
super.
you, so I guess he's interested.
He did not work for
But he works for
Binion.
Concrete Industries, right?
No,
No, Binion Construction.
Who was not our client.
But regardless, the pictures were taken. Does it matter who he worked for? The pictures were taken.
of
Do you
course,
think they were doctored? Is that what you're saying? The pictures were doctored?
No, that's not what I'm saying. I'm
Okay, so
saying
then
they
the
don't
pictures were
depict.
taken. He fell at around 9:30. He arrived at work around 7:45. The pictures were taken when the other gentleman arrived, which I'm not sure exactly what time that was. I asked you, but I guess you're not sure. But let's say 2 hours before that, maybe 3. Are you saying that it melted by that time? He
Well,
says the
saying
plaintiff says it was the same.
Well, I'm saying that they don't depict the conditions that existed. And beyond that, there is conflicting. I think the really important thing that the trial court found is there's conflicting testimony here.
Well, didn't Mr. Romano testify, I thought, that he arrived at approximately 8 o'clock in the morning on the roof, which made it hard for him to take a video at 6. And I thought he testified, maybe I'm wrong, that he took the video because he just wanted to have it just to show how horrible the conditions were on the job. That's why he took the video.
Okay, but yet he never reported the conditions to anyone. We don't know the angle that the video was taken. We don't know if it represents the whole roof. And there is a portion of the video you can see that the roof had been cleared. And there's conflicting testimony here. Mr. Stewart
Where was that picture? I missed that picture where it showed that the roof was cleared. Oh, do you know what page that was on? I wanted to take
well, I'm discussing the video that showed that it was
clear.
But Mr. Stewart affirmatively testified that there was a cleared path free of snow and ice, and which he himself walked that morning to get from the stairs to the area where plaintiff was working. So the facts that counsel was citing to, they go to credibility, which are for the trier of facts not to be resolved on summary judgment.
Well, it depends usually what the evidence is that creates the conflict, right? I mean, if a plaintiff says 2 and 2 is 4, and a defendant says it isn't, it's 5, that doesn't prevent us from finding summary judgment if we have a calculator, right?
Right, but
just because someone says it doesn't make him credible or doesn't make it a triable issue of fact.
I understand, but at the same time, there's conflicting testimony here. And the videos and the pictures don't
So if we
that.
find, I'm sorry, I didn't mean to interrupt you. If we find that Mr. Stewart's testimony is inconsistent with the video and the photos, do we have to credit it?
Well, in addition, well, counsel says it's clear where he slipped. It indicates an area where they weren't working. He shouldn't have been there. And so that is also needs to be taken into account. And that was the testimony of Mr. Stewart.
He was walking back and forth. I mean, where was he? Where was he that he wasn't supposed to be there? I mean, he had to come up a stair on one side of the roof and then walk across the ice to get to the other part of the roof. So where was he going? I mean, 5 buildings away, where was he going? Then it was not where he was supposed to be.
Exactly.
Well, there was a cleared path that he should have been walking from the area where the concrete pour was to the stairs, and he was way outside of that area.
Well, that should be, it should be relatively clear. There is nothing but ice in these photos. I mean, you can't even get a hint of a path. So it's to say that there was this clear path that he's supposed to be on. I can't imagine where it was.
Mr. Stewart testified to that, and the photo and the videos don't show the whole roof. You don't know the angle that they were taken at. They were taken by the video was taken by an interested witness, and
an interested witness before the fall.
Well, of course, but he was also plaintiff's friend. We don't know if they were in this together, that they're going to
threw
split
himself
the money.
onto the ice. Okay.
Okay, thank you, counsel.
Thank you.
They're in this together.
Your Honors, just to address the time sequence. So Mr. Stewart was there at the beginning of the day at between 6 and 7 a.m. Romano testified he went up there at about 8. I didn't see, Your Honor, Justice Renwick, I think you mentioned 9:35. I don't remember that, but I did see on the...
I thought that it said that the slip was about 9:30 a.m.
Okay.
Page 1412.
Thanks. Thank you, Your
Maybe
Honor.
I'm
I
wrong,
saw
but
the
that's one
incident
place
report,
it
it
is.
said 10:15, so it was certainly around that time. And the subsequent pictures, the photograph that Stewart took was taken at about noon. At least that was according to what Romano said. And if you look at the photograph, even though time had elapsed and it was a warm day, there was still plenty of ice and snow there, as you can see on that photograph at page 587. And you can also see, if you have a pretty good picture of the entire roof, there wasn't any cleared path there. As far as an interested, disinterested, I mean, interested witness is a term of art, and the standards for being an interested witness were certainly not meant here. He had no financial interest, whatever, so he was not an interested witness, and he was a foreman, and his livelihood depends on his employment with the subcontractor in this case. So we think for all those reasons, there is no real issue of fact. And, in accordance with Rodriguez and the case law, we believe we're entitled to summary judgment, even if there were a question of comparative negligence, and we don't think that there is.
Thank you.
Thank you very much.
Thank you. Thank you both. Mena. Yeah, I'm sure too. I'm with you.
Good afternoon, Your Honors. May it please the court. Larry Green with O'Toole Scrivo for the appellants 485 7th Avenue and Magnetic Builders Group, Inc. This case comes down to something very simple. People cannot see through concrete. Unfortunately, that's what would have had to happen in order for my clients to be able to detect the corrosion that was within the ceiling slab, the concrete ceiling slab, that was a permanent part of the building.
Right, but that's why 240 is not set up as a negligence statutory claim, right? So if you have certain cover activities like demolition of a permanent structure, hasn't this court found that is sufficient? I mean, we don't expect you to get like x-ray the wall. We know that there's certain risk inherent in certain professions, in certain activities, and that's what the statute addresses.
Right, Your Honor, and as Your Honor is undoubtedly aware, this court has set forth the rule regarding permanent structures in the Jones case, Espinosa, and then reaffirmed that in Vasquez. I know Your Honor was involved in the Jones case. And in that case, the court looked at the disputes between the various appellate divisions and found the rule that where the accident arises out of a failure of a permanent structure, the plaintiff has the burden to show that the collapse was foreseeable. There's no way to show that the collapse was foreseeable unless you can tell unless you can see what caused the collapse.
But wasn't there a DOB violation that specifically found that there was no reshoring in place to prevent the slab from dislodging? So, I mean, when you're doing the type of work that was being done, don't you have an obligation to anticipate that there could be dislodging and a necessity for reshoring? Don't you have to check that up? Isn't that part of the obligation to protect the workers?
Your Honor, I'll answer that in two parts. First, the violation was dismissed. That's on record 193. It's 351-828-86X is the violation number. It's a matter of public record. You look that up. That's been dismissed. And as for the obligation to anticipate this corrosion, the Miseriti case holds that an owner is not under affirmative duty to tear apart their building to look for any...
But we're not talking about tearing apart. This is a motorized chipping hammer that's used on a building that's in such condition in the first place that it needs to be demolished. So here he is working right at the wall that is adjacent and adheres to the ceiling with this motorized chipping hammer. I don't know why that's so unforeseeable that one would cause vibration to the other, which is already in decrepit condition.
Your Honor, I
Now,
would push
not
back.
only that, but with regard to the foreseeability, I think McKeon says that he inspected it. But his inspection, I don't know exactly what kind of inspection it was, because he doesn't do any test or anything, I mean, not even a tap on the wall. So I'm not really sure what that kind of inspection, was.
Well, Your Honor, so there's two parts to your
There-
question, I believe.
there
The
are.
first is, we'll push back, this was not a building that was being demolished. They were converting this into the Moxie Hotel. And they
Right,
were
but
not
that area was being demolished or
No,
whatever you
Your
want to
Honor,
call it.
there was a non-structural brick on the wall that was below the ceiling slab that was being taken away, probably to put some other decorative brick. But they weren't demolishing that ceiling slab. They weren't demolishing this building. As for,
They were demolishing the wall.
they were taking off non-structural brick, facial brick on the wall, which is different than demolishing the wall itself.
Well, I don't know, when you're using an electrical motorized chipper, you're pretty much
Yeah.
doing what you would do if you were demolishing it, weren't you? I mean, other than having a swinging, demolition ball, you
Yeah, I know McKeon, the superintendent, says, non-structural facial break. I mean, tomato, I mean, you were demolishing a wall in a permanent structure. And that's what Jones talks about. It's clearly was in poor condition enough, which is what Jones, again, talks about. It was in poor condition enough that you needed to demolish it.
Your Honor, I will push back on that. There's no testimony by the plaintiff that the building was in a dilapidated condition or in disrepair. And the evidence is that this was being renovated. Oftentimes, buildings have things taken out in order to change the look of it. It doesn't indicate that they're necessarily falling down. The plaintiff could have said, this is a dilapidated building, but he never said anything of that sort because there's no evidence whatsoever that there was any reason to believe that this ceiling was going to fall down.
It's not worth it.
Okay, thank you.
Good afternoon, Your Honors. May it please the Court, Ken Gorman for the plaintiff respondent. Since the plaintiff's work involved demolition of walls and structures that was adjacent to the ceiling that collapsed, it was foreseeable that the ongoing demolitions operations would weaken surrounding structures. In the labor law and the industrial code clearly require the ceiling to be braced and shored to prevent it from falling due to the progress of the work during an ongoing hand demolition operation. Espinoza and Vasquez are completely not on point. I mean, in Espinoza, neither party was entitled to summary judgment because the record gave rise to tribal issues of fact as to whether the failure of a cellar, vault beneath a sidewalk, a complete permanent building structure was reasonably foreseeable. And in Vasquez, the court found that a question of fact existed as to whether the collapse of a permanent staircase was foreseeable given the conflicting testimony from plaintiff and the defendant regarding the condition of the stairs. In this case,
But what I hear from counsel, from your opponent, is that, this is not like Mendoza, for example, that involved water seeping into the walls itself, permanent structure, agreed. Jones, which really, we're talking about walls in really poor condition. He's saying, no, we were going to make this a better structure. There's nothing to indicate that, yeah, we got to get rid of a few walls, but I guess he's challenging the definition, actually challenging whether this is the kind of activity, demolition activity contemplated in the statute.
absolutely, because all demolition, most demolition activity involves building a better structure. But
Well, what makes it foreseeable that the ceiling was going to fall?
when you're using an electric motorized chipper, chipping concrete in a wall that's adjacent to the ceiling, it's clearly foreseeable that the structural integrity of the building, of the ceiling, is going to be affected. In addition, the industrial code clearly requires ongoing inspections while these types of demolition occurs. And
Is there any evidence that there was any sort of inspection either before?
before, yes. Mr. McKeon testified that he conducted an inspection before, but he didn't.
What did that inspection involve, though? I guess that's
Visual
my real
inspection,
question.
But Mr. McKeon clearly testified that he wasn't a professional at pages 146 to 145 to 146 of the record. He wasn't even qualified to make a determination as to what caused the ceiling to collapse.
He never testified that he inspected the area for stability or anything like that, for example.
Prior to the incident, but
Right, prior, I'm
at the
talking
very least, it would require an inspection from an engineer or some qualified individual to determine the structural integrity of the ceiling.
Did he even testify at all about how the ceiling appeared? Like how it looked? During his
Under these
reported
circumstances,
inspection?
I don't think just a visual inspection would be enough. I think you would
But
need,
I'm asking if he even gave testimony as to what the ceiling looked like.
I'm not, I'm not
Okay.
sure. I don't
Yeah.
recall him testifying to it.
He did challenge whether demolition was actually being done. He keeps saying that the plaintiff was involved in probing. I don't know exactly what that means. Removing part of the facade, right? So that the designer can see underneath, is what he's saying.
Wow.
And then he talks about plaintiff not really removing a wall, demolishing a wall, I guess, but he was doing soft fit. Like, what is that?
I mean, I think the facts are pretty clear. I mean, the plaintiff was engaged in demolition work on a non-structural facial brick wall on the inside of a cast iron storefront using an electric chipping hammer while standing on a scaffold. As he was chipping the wall, a large chunk of the concrete ceiling fell on him. These facts are pretty clear. I don't think anything is in dispute.
Well, counsel is disputing it.
Well, I mean, conceptually, yes, but factually, I think it's pretty clear cut. Thank you. Anything else?
Go ahead, you still got 30 seconds.
Well, okay. With regard to the industrial code, section 23-3.3 subdivision C, although not brought up on direct argument with my adversary, it should be noted that there is a clear violation of this provision because it required ongoing inspections, but there was no ongoing inspections at all. And Mr. McKeon testified that he did it prior to the demolition, not during the demolition. Thank you.
Okay, thank you.
Your Honors, I would argue that the mere fact that you're using a chipping hammer to remove brick that's just non-structural, it's facial, it's just on the surface, does not necessarily indicate that you should expect a ceiling that's been standing there for...
Well, it may not indicate that it's foreseeable. I disagree with that, but it may not indicate that it's foreseeable. But where does the inspection? It doesn't even look like there's any inspection. I mean, there's nothing from McKeon in the record that I see that states what the condition of the ceiling was. In other words, if you inspect something, you at least look at it and can describe what it looked like before so that you may suggest why you didn't think it was foreseeable. He couldn't even say that. There's nothing in there that says anything about what he found the condition of the ceiling to be. So the idea of saying that it's not foreseeable when you can't even identify what it was doesn't look like you did much of an inspection.
Well, to the contrary, Your Honor, he testified that he inspected before the accident.
That's what I'm talking about.
But he inspected the scope of the work, not necessarily the structural stability of the ceiling.
Well, he testified he performed an inspection and it was not able to detect the corrosion within the slab. I would submit, Your Honors, that it's just simple common sense. You cannot see corrosion inside of a slab no matter what you do from an external visual inspection. It goes back to my earlier point. People can't see through concrete. No amount of inspections under 3.3C, however many have been done.
But I don't know why you keep saying that, because in Mendoza, in Jones, no one, I don't think this court has ever said that you require an X-ray machine to see what's inside. We look at the actual activity, and when we see a chipping gun and other equipment, a crowbar, that tells us that that stuff is coming down. So we get to define it by what it is that you're doing, not by some X-ray machine.
I would just push back against that, Your Honor, because I know in those cases, in the cases where an issue of fact has been found, there's been some testimony that was dilapidated or disrepaired condition of the building. In this case, there's none of that.
I have to tell you, I hate to put in personal experience, this is not a personal experience, but if I saw somebody using an electrified motorized saw cutting out a wall that had brick, I wouldn't be standing next to them underneath that ceiling. I would just think, this is not a good idea.
Well,
And
that
here
may
it is,
be
somebody's working. It seems almost common sense. I know you're not saying that, but it seems almost common sense.
That may be a great rule for personal preservation, Your Honor, but as a matter of law, there's no
I don't know,
case law that
we
says-
have to use common sense here.
There's no case law that
well.
says the mere use of a chipping gun in of itself makes it foreseeable.
No,
that
that's not what we're saying at all.
But counsel, can you address counsel's argument that there was no evidence of any continuous inspections? Can you address that?
Thank you so much, Judge. And the reason why that is because plaintiff's counsel was deposing my client and they didn't follow up on it. They asked, he said there was an inspection and they didn't ask any more questions about that. So if there's a lack of record of the details of the inspection, that's because the plaintiff got an answer he didn't like and didn't want to follow up on it. There's no evidence in the record whatsoever as to how many inspections were done or exactly the manner in which they were done. All we know is he did the inspection, it wasn't detectable at the time he did it, and they didn't want to ask any more questions about it.
Thank you. Thank you both.
Thank you, Your Honors.
South College? Yeah, it is cool. Go ahead, Counsel.
Good afternoon, Your Honors. May it please the Court. My name is Matthew Aronson from Troutman, Pepper, Hamilton, Sanders, on behalf of Plaintiff Appellant South College Street, LLC. There are two sets of conveyances at issue in this case. There is a set of conveyances, approximately $21 million, made by Infolaw Corporation, who was a judgment debtor to South College Street. There's also $13 million in conveyances made by Infolaw Corporation's parent, Infolaw Holdings. I'd like to address the first conveyances, the corporation conveyances that was addressed by the court. The court dismissed the initial complaint and denied leave to amend on the grounds that those payments made by Infolaw Corporation were payments of an antecedent debt. In fact, the court stated that it made its ruling based on documentary evidence. However, there's nothing in either the motion to dismiss ruling or the denial of the motion to amend that actually identifies what documentary evidence the court relied upon in determining that those 15 payments of approximately $21 million were repayment of an antecedent debt. There's simply nothing in the record to show that. On appeal, the Aries, the respondent...
So there's nothing in the record suggesting secure debt payments?
No, there is in the record, and that's what I was going to get to, Your Honor, that there was a credit agreement. We don't dispute that there was
a credit
agreement between Infolaw Corporation
Right.
and Aries. We don't dispute that existed. What we do dispute is that the payments identified in the complaint as being fraudulent, the 15 identified payments, were made pursuant to that credit agreement. There is nothing in the record that speaks to those particular payments.
So you think they were just giving them the money?
Well,
if you have an existing credit agreement and their payments being made thereto, isn't it logical that this was secure debt payments?
I think that's a leap that's made that is not necessarily true, Your Honor. The situation here is that respondent is a preferred equity holder of holdings. So this is not a situation where you have a third-party lender and a credit agreement where they're extending money and payments are being made under a payment schedule pursuant to a note. What we have here is, I don't want to call it haphazard, but payments of varying degrees at varying dates, sometimes on the same dates, spanning several $100,000, spanning several $1 million, in numbers that never seem to match up to anything. There's no way for us to know, as the judgment creditor, what the purpose of those payments were. And because of this relationship between the respondent and corporation and holdings, it's entirely possible those were not repayments of debt. There's nothing in the record. Respondent could have submitted documentary evidence to identify that issue, and they failed to do so.
And it's their burden, you're saying?
It is their burden. The court was supposed to accept our allegations of true. We said
Right.
that these were payments, without equal value. It was the
And
burden.
you say you have no obligation to plead an exception to Englander,
We
right?
do not have an obligation to plead an exception to Englander. We
Okay.
plead that these payments are not payment of antecedent debt. I do want to turn to the second issue.
The thing is, don't you have to plead more in this type of an action under Delaware law to, where you're looking for an alter ego situation? I mean, we know that the defendant is not the judgment debtor, somebody else is, the corporation, and that's the problem, right? So don't you have to plead more according to Delaware law than you did? I mean, that's one of the concerns I personally have.
Yes, Your Honor, and I was going to turn to that. The second issue is the payments made by holdings, which admittedly is not a judgment debtor, to Ares. Those payments have nothing to do with the Englander exception. Those are payments that were not made pursuant to an antecedent debt. But the issue.
So what's your burden with respect to what elements do you need to show if you want to go? I mean, you're saying Holco is an alter ego of the entity that you have the judgment against.
Correct, Your Honor.
So what evidence do you submit for that? What is the standard that you need to meet?
Right, and that's what's been debated back and forth in the briefing as to what the appropriate standard on that issue is. Right. And we submit that the court below, relied upon too exacting a standard. And what the standard is, and I think it's established, this court in Walnut Housing Associates has stated the standard, and it basically has this allegation that the corporation has created a sham entity designed to defraud its investors and creditors.
Right.
However, the court said it had to be and created for no other purpose. So basically, you'd have to have a fraudulent entity. The case law we cite simply points out that the court can consider whether there was an injustice created by the alter ego.
But the cases you cite are not New York cases. They're not New York cases interpreting Delaware law. They're not Delaware cases. I mean, one of them, you basically have federal cases out of Texas and Oklahoma, I believe.
Well, we have NetJets, which is a Second Circuit case, Your Honor. And we also have cited to Jones Lang LaSalle, which is a New York State court case. And that case essentially adopts NetJets, Second Circuit case, and has a lesser standard than the standard that the court applied. But one thing I want to point out from the Walnut case is that even if the standard that the court applied to some extent, which is referred to as the Cross case, which is a little bit of a lesser standard than what the court applied, in that case, this court specified that the court will often consider a combination of factors, including whether a company was adequately capitalized or solvent, whether corporate formalities were observed, whether the dominant shareholder siphoned company funds, and whether, in general, the company simply functioned as a facade for the dominant shareholder. That's exactly what was alleged here. And I posit for this court that the allegations and the pleadings in the proposed amended complaint fit squarely within Walnut Housing Associates, and certainly within Tribeca and the other cases which have a lesser standard.
Okay. Thank you.
Thank you, Your Honors.
So,
Good afternoon, Your Honors. Stan Che with Friedman Kaplan for respondent. Let me start with what Justice Schechter actually held. She held, and we count at least 5 times where she said this in the 2 orders that plaintiff is appealing from, that her decisions to dismiss and to deny leave for amend was based on plaintiff's failure to plead facts to state a cause of action. So that's plaintiff's burden. They have to plead facts to state a cause of action. They didn't. So taking on where plaintiff left off, let's talk about the documentary evidence. The factual allegations in plaintiff's complaint state that in 2011, Ares entered into a credit agreement with debtor. This credit agreement was secured by a lien of substantially all assets of debtor. And the important thing, if you look at paragraphs 16 and 17 of their proposed amendment complaint, they say repeatedly that this agreement imposed debt payment obligations that debtor was trying to make and did make over the course every year. And 15 of these payments from 2015 and 2016 are the secured debt payments that they are trying to avoid as fraudulent conveyances. Justice Schechter, based on those allegations alone, could easily have concluded, and as Your Honor said, it's logical to conclude that these payments are repayments of debt under the credit agreement. Now, what do they have? What factual allegations do they have that these payments, these 15 payments, were anything other than debt payments under the credit agreement? They have nothing, Your Honor. We've said they had nothing, and Justice Schechter, when they tried to make this argument before her, said, all you have is speculation. And like Your Honor said, I heard a few arguments before, just because you say 2 + 2 = 5 does not make it a tribal issue of fact. It's their burden to allege facts to establish that these payments, or to at least allege that these payments were other than secured debt payments. They haven't. And what's, I'll be honest, a little astonishing to me, Your Honor, is if you go to their reply brief, and this is the first time I've seen this, in their reply brief on page 4, they claim to have, quote, specifically, end quote, allege that debtor made, quote, other payments, end quote, to Aries. First time I've seen this. And they cite 2 paragraphs, paragraph 12 and paragraph 25 of the proposed amended complaint. And I looked at those paragraphs, Your Honor, and I cannot find the quoted and emphasized language there. I cannot. I don't know where they got it from. And I've read the rest of the complaint. There are references to other payments, but those references are in the context of Holdco making other payments. Holdco making
So
dividend.
what you're saying is the fact that he indicates that the payments that were made may have been numbers that don't exactly equal up or whatever, you know, it's hard to fit them into what was actually owed under the credit agreement. That wasn't enough for him to allege. We know that sometimes plaintiffs don't have all the facts when they're issuing a complaint alleging especially fraud, but they didn't even do enough to get there, which we understand under Delaware law is even a tougher standard than you might have here in New York.
Right, so a couple things to unpack there, Your Honor. First of all, this notion that the amounts are in variance numbers, that's something, again, we're seeing for the first time in a reply brief. So that's one. Number 2, it's not even completely accurate. He said, for example, that there were 2 payments made in April by corporation. Read their complaint, paragraphs 26 and 27. One payment was made by Corp, the other payment was made by Holdco. And third, at a minimum, Your Honors, we have to see some sort of factual allegation that there's another source, another reason for debtor to be making these payments. They simply haven't alleged it, and to the extent they have attempted to argue they've alleged it, it's not there. It's not in paragraph 12. It's not in paragraph 25.
So they need to show that the payments were designed to defraud.
When it comes to the Holdco payments, they have to allege something to show that the payments were designed to defraud. Right. And again, Your Honor, these payments, the preferred unit payments, these were entered way back in 2011, long before plaintiff ever entered on the scene. It was a year before the lease was executed, 3 years before plaintiff ever showed up and took over on a lease, 6 years before any default occurred under the lease. And we think Justice Schechter got this exactly right. When plaintiff came into the picture in 2014, if this was an issue, if the fact that Holdco had this obligation, as plaintiff said, to make these equity payments was an issue, plaintiff could have gotten a guarantee from Holdco.
Should have gotten them both to be guaranteed.
That's right.
Is that what they said?
That's right. If they'd done that, we wouldn't be here arguing the alter ego issue, but they didn't. And now they're here trying to use Delaware's extremely exacting alter ego test. We don't deny that. That's what the Supreme Court said in Cross. They're coming in here trying to use the alter ego test to make Holdco a retroactive guarantor. That's not appropriate. They have not pled the necessary element of fraud. And again, Justice Schechter said the first time around, in her first opinion, that the fact that plaintiff continued to receive and retain rent, 27 payments, $13.5 million after debtor first allegedly became insolvent, she said that was an inverse badge of fraud. And in plaintiff's appeal, he doesn't even acknowledge that she said that, let alone address it. And for these reasons, we ask that Justice Schechter's two opinions be affirmed.
Thank you, counsel.
Your Honor, let me start with addressing the issue of the payments that were made, this inverse badge of fraud. These were payments made, the plaintiff was the landlord of an operating school.
Right.
This was the party that had to be paid, whether or not you were insolvent, because otherwise you couldn't operate your school. So the fact that a party is insolvent but continues to make some of its payments or its obligations doesn't mean that the payments were not fraudulent conveyances at a time when a party was insolvent. It's simply just an analysis of whether or not the party was insolvent under the DCL test. But I do want to jump back to the issue, and I want to be clear about this. There are two separate tranches of payments with different parties, and the alter ego issue we talked about doesn't really impact the question of the payments made by corporation. And again, the paragraphs, the court will certainly read the complaint, I'm sure. They'll read the proposed amended complaint. If you read those allegations, there is nothing in that complaint whereby we allege, the plaintiff alleges, that the 15 identified payments were payments pursuant to the credit agreement. We simply don't know. As one of your honors noted, we don't necessarily know what those payments were. We think we're entitled to discovery. In order to find that out, we think we've pled enough to get us past that point. Thank you, Your Honors.
Thank you both. Excellent argument. Last, People versus Challenger. Go ahead, counsel.
Good afternoon. May it please the court. I am Rita Maxwell with the Bracewell firm, and together with the Center for Appellate Litigation, I am pro bono counsel for the appellant Levi Challenger. I'd like to start today with our point one, the identification of Mr. Challenger in the security footage by New York Police Detective Nicholas Isolano. The ultimate issue in this case was the identity of the perpetrator depicted in that footage. And when Detective Isolano, a 20-year veteran of the NYPD, testified that it was Mr. Challenger in that video, he took that question from the jury. Detective Isolano did not know Mr. Challenger. He only encountered him 3 months after the crime, when he participated in Mr. Challenger's arrest. And the change in appearance here was minimal. It was simply the donning of glasses at trial. As we noted in our briefs, the people rely on an instruction to mitigate the prejudice and the harm. That instruction was insufficient given the nature of this testimony.
I mean, you agree that a detective can testify as a lay witness regarding the identity of someone in a videotape. So that principle, you say, is okay. Is the fact that Detective Isolano, I mean, what about his testimony or his stature as a 20-year detective take that issue from the jury?
Well, the identity of the perpetrator was the ultimate question, and it was not a case of overwhelming proof. And if a juror hears that a detective who has participated in hundreds of investigations, hundreds of arrests, has formed an opinion that Mr. Challenger is the perpetrator, it's likely that they will defer to him. Also here, Detective Isolano did not know the defendant at the time. There are cases where police officers and law enforcement are able to testify, but it is usually based on, and in fact in every case, it is based on their encounters with the defendant, sufficient that they knew him. The standard is, did you know the person? And here, Detective Isolano did not know Levi Challenger, and there's nothing in the record that establishes that he had sufficient familiarity with him to give this kind of testimony.
So you're saying the lay witness has to have some connection to be able to identify it, not sit as a 13th juror and say, oh, yeah, that's him.
Absolutely.
Okay.
Absolutely.
All right.
And also in this case, it was simply donning glasses, and that has not been a sufficient change in appearance. When the other cases where there's been a change of appearance, it's usually something more substantial.
But you agree that I mean, I assume that the jury will be charged with the standard charge, namely, you know, you are the ones that determine the facts. You are the ones who determine whether that's the individual depicted in the video, et cetera, et cetera, et cetera.
Typically, yes. The instruction here was given only after the second identification of Mr. Challenger in the video. We believe it was insufficient given the sort of the nature of this testimony, given how little Detective Isolano knew Mr. Challenger and the minimal change in appearance. But I would also note that it was not the instruction that is sort of contemplated in Russell or Coleman. It was not an instruction of this is just one of the facts and circumstances that you may consider and you alone make the determination. It was simply the detective's opinion is not binding on you and you make the determination. So given how far out of bounds that testimony was, we don't think that that instruction was strong enough to mitigate the prejudice and the harm here. I see I'm already out of time.
Yeah, I'm sorry. I'm taking notes, so thank you.
Thank you.
Good afternoon, Your Honors. Diana Wang for the people, and may it please the court. There is no question that detectives, such as lay witnesses, can identify defendants due to a change in appearance.
But what was the
Sorry.
what was the change in appearance here?
That defendant wore glasses, and at the time
So he had
of
on a pair of
arrest-
glasses. Most of these cases, I mean, if you took off your glasses, I think I'd still recognize you outside. I wouldn't have to ask you to put your glasses back on, even with the face mask, to figure out that it was you. So if this is the main issue for the jurors, to have to identify somebody in a video, the jurors don't know that the person, and the officer didn't know the person except for that day when he saw him without the glasses. It's practically the same. I mean, usually in these cases, don't we see an officer testifying where somebody has now grown a beard or has gotten some tattoo?
Well, Your
or
Honor,
I'm not finished. Or has grown out his hair or her hair in some way. Why is a simple pair of glasses now carte blanche for having an officer testify to what the jurors, unless somebody had some impairment that they couldn't see,
Your Honor,
the jurors to be able to do that?
I think eyeglasses frame a person's face and change the shape of someone's face the same way that a line of stubble or a beard changes the shape or frame a person's face.
Well, that's the first time I've heard that.
And they are a
I mean, the people that wear glasses and then put contacts on, no one is suggesting that we couldn't identify them.
I disagree, Your Honor. I mean, as a personal anecdote, I wear glasses all the time. They're a permanent feature of my face, and many of my friends don't recognize me without them. The question is whether or not the detective is more likely than the jury to identify defendant.
But isn't that precisely the problem? Because you have a detective who doesn't have any prior knowledge of the defendant.
Well, he arrested defendant. So
you can always make an argument that a detective is going to have more knowledge than the juror. I mean, really?
Yeah.
As an attorney, you could always make that argument. It's like saying you can indict a ham sandwich. If you wanted to, you could make that argument.
That's not the only salient fact here. The fact is that he knew the defendant before the change in appearance, and we're arguing that the change in appearance is sufficient.
Yes, we understand that. That's the only reason that you would be able to even think about it. But a pair of glasses, and there's no evidence in the record as to what the glasses looked like, I don't think. You say it makes such a difference. Well, there are some glasses maybe that are so thick and heavy and large, you know, these days people wear them to have some character, but there's no suggestion that these were anything unusual.
Well, I think that's actually cuts in the people's favor, because what the jury did is actually evaluate whether or not the glasses are thick or thin or a prominent feature of his face.
Well, they evaluated it in the context of having heard a detective saying, yeah, that's the guy.
Right,
That's
which was
powerful.
accompanied by a contemporaneous instruction that it is just an opinion by the detective and that it is
Right, and that's why I asked the question before, whether, I asked that question and there was a response, but I still have concerns that basically, usually when we allow this kind of testimony for someone to sort of, I don't want to say usurp the jury function, but basically help a juror to make that identification, usually that individual has known the person, particularly around cross-race identification, someone who has known the defendant from the community, that has had some prior contact, maybe a prior arrest of that individual, but not someone who has just changed glasses and somehow you need to tell the jury, yeah, that's the guy.
Well, the point is, the standard is whether or not the detective is more likely than the jury, and this court has never held that changing glasses is not sufficient. So here we are faced with arguably new facts, which is just changing glasses, no beard. And the question is the low standard for admissibility met here? And I will also argue, Your Honor, that the evidence was harmless in the face of the mountain of evidence.
Maybe that's your better argument, because this shouldn't happen. It's not necessary. The evidence should be able to speak for itself in a case where a defendant merely puts on a pair of glasses. It sort of, to me, weakens the argument for this kind of testimony.
Your Honor, I agree that it's not necessary in this case, and that actually speaks to the harmlessness of the evidence here, given all of the surveillance footage against defendant.
Okay, thank you.
Thank you, Your Honor.
I'd just like to briefly add a couple points on the glasses. I would like to note for the court that the jury was provided with photos of Mr. Challenger without his glasses on. And when we think about why glasses are not enough, I think the answer is also in the record at 513 of the 228 transcript, where the court noted that had the evidence been open at the time of the jury's note, the court could have had Mr. Challenger take off his glasses for the jury. And so I'd also like to briefly address the harmlessness point.
Okay, you got 30 seconds, so go for it.
This was an identification case built on circumstantial evidence. The victim did not identify Mr. Challenger as the perpetrator. There was no physical evidence tying Mr. Challenger to the crime. The evidence was not so overwhelming that this error could be deemed harmless. For this and all the reasons we set forth in our brief, we ask that the court reverse the conviction of Mr. Challenger.
Thank you so much. Thank you both, and thank you your firm for the services that you provided to the defendant in this case.
Thank you.
Thank you.